A very good evening to all. On behalf of PSG College of Arts and Science, I extend a warm welcome to the inaugural session of the AICTE-ATAL Faculty Development Program on fostering intellectual property rights strategies for advancing healthcare and medical technology innovations. I invite a program coordinator, Dr. K.M. Shaktivel, Assistant Professor, Senior Grade, Department of Biochemistry, and IPR Cell Coordinator to deliver the welcome address.
A very good evening to one and all present here. It's my great pleasure and privilege to warmly welcome you all to the inaugural session of AICTE ATAL Faculty Development Program on fostering intellectual property rights strategies for advancing healthcare and medical technology innovations, organized by Department of Biochemistry and Department of Biotechnology in association with IPR Cell, PSG College of Arts and Science, Coimbatore. At the outset, I wish to express my sincere gratitude to our chief patron, Sri L. Gopalakrishnan Sir, Managing Trustee, PhD Sons and Charities, for his constant support and encouragement. I extend my heartfelt thanks and welcome to our patron, Dr. T. Kannayan Sir, Secretary, PhD College of Arts and Science, for his continuous motivation in all our academic endeavors. I take this opportunity to welcome our chairperson, Dr. M. Sengutuvan Sir, Principal in charge, PhD College of Arts and Science, who has always been a guiding force and a strong pillar of support. I welcome you, sir. I am delighted to welcome our Vice Principals in absentia, Dr. M. Jayanti Ma'am, Vice Principal Aided, and Dr. M. Umarani Ma'am, Vice Principal Self Finance, whose leadership has been instrumental in driving growth of our institution. And I extend a special welcome to our conveners, Dr. B. Ramesh, Head of the Department of Biochemistry, and Dr. J. Sendil Kumar, Department of Biotechnology, for their dynamic efforts in organizing this program. We are greatly honored by the presence of our distinguished chief guest, Dr. Padmavati Machiganti, Professor, Rajiv Gandhi School of IP Law, IIT Kharagpur, who has kindly consented to deliver the inaugural address. Madam, we are indeed privileged to have you with us today. I also take this moment to welcome my fellow coordinator, Dr. R. Rashmi, Assistant Professor, the co-coordinator of this program from Department of Biotechnology, who has been an integral part of this program. Last but not least, I extend a warm welcome to all our resource persons, participants, research scholars, faculty members, and colleagues. Your presence and active involvement will surely enrich the success of this FDP, and I'm proud to share the information. We have registration of participants from 20 different states. Around 139 participants are joined. Totally 240 are registered. With this, I once again extend a cordial welcome to each one of you. Thank you.
Thank you, sir. To begin this inaugural session, I now invite our respected principal, Dr. M. Sengutuan, to deliver the presidential address. Sir has always been a source of constant encouragement and guidance for all academic and research initiatives of our institution. We are honored to have you with us, sir.
Am I audible?
Yes, sir.
Most respected Secretary Dr. T. Kannayan Sir of our college, the chief guest of this today's function, Dr. Padmavati Manchikanti, Professor IIT Kharagpur, and other resource persons who are going to deliver their address for this AICTE ATAL sponsored FDP program regarding fostering intellectual property rights strategies for advancing healthcare and medical technology innovations. The persons who are responsible for taking care of this function organized by the Department of Biochemistry and Department of Biotechnology, IPR cell, vice principals, deans, heads of the various departments, and the head of the Department of Biochemistry, head of the Department of Biotechnology, and highly knowledgeable teachers of our college who are involved in this FDP program, the two happening online after the class hours, and delegates from our own college and other colleges across the country, very meticulously involved in this program to know about the intellectual property rights strategies so that you can excel in your patenting all the products that you develop for the betterment of human being, the two in the healthcare products and medical oriented innovations. Only then we can take care of the health of the born people and going to born in the future. So it's a very important program. I feel that I am honored a part of it, and our college is also a part of it. And this is a very important movement that we are taking for the betterment of human being. Not only that, in order to take the students forward, they should also gain more knowledge regarding the subject so that they can do wonder in the future, and thereby our institution will be rated in high level in the future in the country as well as in global level. So I wish you all the best for the program, the grand success of this program. Thank you for the opportunity given to me. Thank you.
Thank you, sir, for your valuable insights and encouragement. We also have with us our conveners, Dr. B. Ramesh, Head of the Department of Biochemistry. I invite sir to share a few words.
Am I audible?
Yes, sir.
Respected Dr. Padmavati Manchikanti, Professor, IIT Kharagpur, Secretary Dr. T. Kannayan Sir, Principal in charge Dr. M. Sengutuvan Sir, Dr. J. Sendil Kumar, Convener and Head Department of Biotechnology, Program Coordinators Dr. K. M. Saktivel and Dr. R. Rashmi, participants across the country and participants from PSG College of Arts and Science. Good evening to all gathered online. First of all, I thank the management of PSG College of Arts and Science for permitting us. Am I audible?
Yes, sir. Yes, sir.
First of all, I thank the management of PSG College of Arts and Science for permitting us to conduct the 6-day online faculty development program, fostering intellectual property rights, strategies for advancing healthcare and medical technology innovations, sponsored by ATAL Academy. I also take this opportunity to thank our Secretary Sir as well as our Principal Sir for their constant support and guidance in organizing this faculty development program. I appreciate the program coordinators for taking this initiative and kickstart the program, and I hope that it would benefit all the participants from 20 different states across 139 institutions. I give a warm welcome to all the participants, and my request to the participants is to give the priority for the next 6 days in attending all the sessions, because as per the guidelines, a test will be conducted at the end of the program and certificates will be provided for the participants with a minimum 80% attendance and 70% marks in the assessment. So I thank the organizers for giving me an opportunity to act as a convener for this program. Stay in line and enrich your intellectual concepts in health aspects. Thank you all. Have a great day ahead.
Thank you, sir. I invite Dr. J. Senthil Kumar, Head of the Department of Biotechnology, to share few words.
Good evening, one and all present here. On behalf of the Department of Biotechnology, it's my duty and pleasure to invite you all for the 5 days faculty development program entitled as Fostering Intellectual Property Rights Strategies for Advancing Healthcare and Medical Technological Innovations, sponsored by AICTE. On behalf of the department, I am very much thankful to the managing trustee for granting us a permission to organize this program in a successful manner, and I am very much pleased to thank the principal in charge, Sir Dr. Sengutwan sir, for being an inspiring person to push up all us in conducting such a wonderful events. And I am also thankful to the Secretary Sir T. Kannayan for providing me an idea to get up with more insights to the faculties and the principals, vice principals, and I also welcome everyone for the program. And my special welcome to the resource person. And on behalf of the Department of Biotechnology, I take my pleasure to invite you all for this program. And this program will be an innovative with in respect of IPR. And I'm very much thankful to the coordinator, coordinator Dr. K.M. Saktivel and co-coordinator Reshmi for organizing such a wonderful program for the benefit of the faculty fraternity. And with those few words, I just thank each and everyone, and I put my prayer to for the grand success of this wonderful FDP. Thank you once again for everyone for attending the program and allowing me to give some. Thank you. Thank you once again.
Thank you, sir. It is now my privilege to invite our chief guest, Dr. Padmavati Manchkanti, Professor, Rajiv Gandhi School of IP Law, IIT Kharagpur, to deliver the inaugural address. Madam, your mic is on mute, I think.
Yeah, I hope I'm audible to all of you now.
Yes, ma'am. Now it's audible. Yeah.
Okay. Thank you so much for the invitation to be the chief, resource person for today. First of all, I would like to, congratulate the coordinators as well as the entire team, principal, the dean of biochemistry as well as biotechnology for putting up a program like that on a day which is an engineer's day today. And this is very, very critical for the area that you're discussing in the entire FDP, which is advanced healthcare and medical technology innovations. So it cannot be a more momentous day than as it is today. Very happy to be back in this forum and to discuss with all of you. I do see a great number of people in this audience who are going to be having a very engaging session, in this entire 6-day FDP. So I have a few thoughts for all of you. When it comes to the area of advancing healthcare and medical technology innovations, one most important thing that we continue to grapple with in the entire healthcare is we call them the affordability is one issue that we face in the healthcare, and accessibility. So these are the two common A's that we come across in the healthcare and medical technology innovations. Now, if they may be an innovation, but it is not accessible. Now, if it is accessible, it not may not be affordable. So we continue to grapple with these two different paradigms when it comes to access to healthcare. Now, you all are aware of the various mission programs under the Ministry of Health and Family Welfare under the Government of India. There are also state related schemes available when it comes to looking at the implementation of healthcare measures and at the various centers, including formal as well as informal mechanisms. So today, when we're really looking at the area of innovation in the healthcare, I think we are rightly positioned. One is where I see there is an ample opportunity is where we are looking at the rural innovations. In rural innovations, we are looking at how we can make available things more at the doorstep. So this can mean access to technologies. This can also mean where we are looking at existing technologies, how they can be utilized for better availability. So this is one thing we look at rural innovations where we have still are grappling with primary healthcare. We are not even talking about secondary healthcare and tertiary healthcare. So I would urge all the participants in this workshop, at the end of the workshop, I would request each one of you to look at one problem in the primary healthcare that you can address. For instance, we have the infectious diseases problem, which is continuing to be there. Then we also have access to devices, where we need rapid diagnostics. Most often, as all of you may be aware, diagnostics comes as a preliminary thing for future treatment. So we need to have point of care diagnostics when it comes to even primary healthcare, and that is something which will be remarkable when it comes to taking care of the rural setting. This is one part of it. Then of course we come to the urban setting. Now in urban setting we have inequity. A lot of inequity is a problem for us. Distribution issues are an issue. We also have supply chain which needs to be also there is inadequacy there. So we need also targeted solutions in the urban fore. So therefore, it is not just the rural setting that we are looking at access to technologies. We are also looking at the same when it comes to urban settings. So all of us have a mobile, right? This is very uniform. This is one thing which you can say internet and the mobile communication area has given us the uh, the enormous value of innovation and technology when it comes to reach. But the same communication or again the same internet is still not able to address the health needs that we have. So that means there is some gap somewhere where we need to fill in. So how do we enable communication technologies to better communicate on healthcare matters, better reach healthcare, continues to be a huge area that we all need to work on. And today, as we see in India, healthcare is an out of pocket expense. It is mostly an out of pocket expense. There's of course Ayushman Bharat, all of that. At different levels you're looking at healthcare schemes by government of India. So when it is predominantly, let's say, out of pocket expense, the relevance of simple reliable technologies becomes very relevant. So addressing primary healthcare is one important aspect that we need to look at. And for that we need to have very better diagnostics, better sensitivity in terms of processes that you can define. So for instance, the other day someone came up with a finger based anemia detector. Very simple invention, and we felt that it has a lot of future. Of course, we need to look at medical standards, if they are being met or not, in the process is sensitive enough. But then we need to really look at frugal inventions also in that area. Then we also need to develop devices which are sensitive to different types of when we look at disease conditions. We also do not have devices which can multiply detect, let's say, two different diseases at one time. So there is ample opportunity, as I can see, when we come to the area of healthcare, where primary healthcare has to be attended. So I will urge all the workshop participants to seriously think about some of these things. In fact, when I hear in my neighborhood here that someone's leg has been amputated, it is a serious concern. It's a serious concern. We know that there is diabetes, and then we know there is diabetic foot, but amputation of a leg is a big, huge difference for a person who is leading a normal life. It changes the life pattern of a person. This is one thing. Now, interestingly, despite the technology that we have, I was again looking at another example right in the last week, wherein we do not have good diagnostics. So, here I'm sharing with you a live scenario of what has happened over the last week, where a student slipped in front of the hostel. Normal fall, unexpected accidents are unexpected, right? So, fell, had an X ray done, but because the X-ray is diagnosed wrongly, instead of that the bone has broken, it was called as displacement. Okay, so 2 days nothing could be done except for a plaster. If those 2 days I had a self-diagnostic kit, it would have been useful to step up. Now it has gone to the level of surgery. So do you see the place where we can come up with innovation? Suppose, let's say I have an X-ray. We all don't need to become doctors, but at least we can become more aware. So if I had a diagnostic, it should tell me that this is most likely not a displacement, but it is actually a fracture, that could have hastened the necessity to go to the hospital and have a review. So this is something we need to really look at. And remember, even our doctors are burdened. The doctor to patient ratio is extremely high, even as per WHO standards in our country. So there is obviously a lot of room for work. The third important area that I would like you all to look at, one is, of course, I talked about primary healthcare, urban setting. And then the third important thing is how to use digital technologies for better medical care. And here I would urge all of you to look at the area of telemedicine. Because post the COVID-19, doctors have also got used to and have been also using it, because we also have e-Sanjeevani and all of that implemented in India. We have the telemedicine area where we can really look at how to come up with innovations in that sector. I was at the Telemedicon last year, and I found this very interesting startup who had a camera like thing which could actually tell you the skin texture, and if you have a skin problem, it will immediately decode. Very simple device. Now, why are we looking at this? We don't want to become doctors, but diagnosis becomes a very early step, and thereby, looking at quickly reaching to medical, care. So there is ample opportunity, I believe, when it comes to different settings. I remember of days when another example I'm giving you is when there is a certain community in Karnataka who will have serious condition if they're given an epidural injection. And this is in a medical, I'm getting into medical terminology. Epidural is something that is given to your spine. Now that community reacts very sharply. They have adverse reactions if an epidural is given to, and most of the operations which they do, they give an epidural, especially for certain, certain surgery. So if we are not aware of this, or let us say that community specific solutions can be brought about, then also we do have a need for innovation. So this is absolutely a great area that you are actually doing this IPR strategies in healthcare and medical technology innovations. And what I would request the coordinators of this workshop is, please have a discussion at the end of the conference, the last day or sometime, where you can collect in some thoughts from your participants. And that will also be a starting point of maybe coming up with a dedicated effort which can foster innovation. I know of PSG is one of the oldest colleges, and they have also done a lot of patenting activity and come up with certain very important innovations. So I believe PSG can also foster that between the colleges. There can be very good collaborations that can happen, and this group itself can be a wonderful group to look taking forward development of certain innovations. And so far as the healthcare and medical technology area is concerned, I myself also work in some of these areas to look at how we can develop what is called affordable healthcare solutions. So I wish all of you a very, very engaging time in this workshop. And most importantly, each one of you should go back with some thought on how you can make a difference with respect to any particular problem that you have in the neighborhood or you have known of, for which there is no solution as yet. I think it'll be wonderful even if you come up with a mobile app, even if you come up with a protocol, even if you come up with, let's say, a manual, or even if you come up with a very simple implementation that can make a big difference. So, wishing you all the very best, and a very good time in this workshop. And with that, I will close my speech. Thank you.
Thank you, Madam, for your inspiring and insightful inaugural address. Now, I take this opportunity to deliver the vote of thanks. On behalf of the organizing team, I express my heartfelt gratitude to our Chief Patron, Sri L. Gopalakrishnan, Managing Trustee, PSG and Sons Charities, for his constant encouragement and unwavering support. Patron, Dr. T. Kannayan, Secretary, PSG College of Arts and Science, for his continuous motivation and guidance in all our academic endeavors. Chairpersons Dr. M. Sengutuvan, Principal in Charge, for his leadership and inspiring vision in steering this institution towards excellence. Co-chairpersons Dr. M. Jayanti, Vice Principal Aided, whose encouragement has always been a source of strength, and Dr. M. Umarani, Vice Principal Self-Finance, for her keen interest and involvement in making this event successful. I place on record my sincere appreciation to our conveners, Dr. B. Ramesh, Head of the Department of Biochemistry, for his dedicated effort and constant guidance, and Dr. J. Senthil Kumar, Head of the Department of Biotechnology, for his active involvement and meticulous planning in organizing this program. A special thanks to our chief guest, Dr. Padmavati Manchkanti, for gracing the occasion and delivering the inaugural address. I extend my thanks to AICTE-ATAL Academy for their support and to all the participants for joining this FDP. We look forward to your active participation in the session ahead. With this, we conclude the inaugural session. Thank you all once again. The technical session will commence shortly.
Dear
It is my
participants,
pleasure.
yeah, we are going to start the technical session now. I invite Dr. Rashmi to start the technical session.
It is my pleasure to welcome our first speaker for the day, Dr. M. Padmavati. With more than 19 years teaching and research experience in IPR, Professor M. Padmavati, Professor, Rajiv Gandhi School of IP Law, IIT Kharagpur, specializes in patents. She teaches the subjects of patent law, patent procedure and drafting, biodiversity law, and TK protection, among other subjects, to undergraduate and master students of law. Her primary area of research includes intellectual property and commercialization of recombinant and herbal drugs and drug regulation, biodiversity law, studies on implementation of IP. She served as the Dean of Law School in IIT Kharagpur between 2017 to June 2020. Prior to joining IIT Kharagpur, she worked for 4.5 years at Monsanto Research Center, Bangalore. She coordinated invention disclosure filing. She has many research as well as consultancy projects from Ministry of Education, Ministry of MSME, Department of Science and Technology, ICSSR, etc. She has been awarded the Microsoft Young Faculty Scholarship in Intellectual Property. Most Powerful Women in IP in 2023. She is an advisor to the IPR cell, IIT Kharagpur. She is a steering committee member of the Vice Kiran internship in IPR program and its course coordinator of the IIT Kharagpur for training women scientists. She has guided 12 doctoral students' research and 60 master students' work. She has 60 papers published in renowned journals in the field of intellectual property law and has few patent publications. She is the member of important professional bodies such as International Trademark Association, Association of Teachers and Researchers in IP. She is a member of the panel on strategy and roadmap for standardization in legal services, Bureau of International Indian Standards, and expert member, West Bengal Biodiversity Board. She is a mentor to several startups under the ABIF IIT Kharagpur. She is the General Council member of National Law University, Jodhpur, and served as member of the Academic Council of National Law University, Delhi. She is also an editorial board member of Journal of Intellectual Property Rights and Journal of Integrative Medicine. She was a former panel member at the FSSAI, Government of India. She is
Yes. Am I audible to all of you?
Yes, ma'am.
Yes,
Yeah.
ma'am.
Thank you so much, Dr. Rashmi, for the kind words. Thank you, Dr. Shaktivel, for the invitation. I know the dedication that with which you both work when it comes to IPR, and how consistently you have been growing in this area and fostering it. Once again, thank you for the invitation, and my best wishes to all the participants as I now move on to share some of the thoughts that I have when it comes to what we know about IPR and how do we see higher education institutions shaping up, and where is it that higher education institutions should look at intellectual property when it comes to institution, when it comes to national building. So let me quickly turn to my PPT, and then we will I will take up the talk. So I hope to see my presentation
No, ma'am.
slides.
No, ma'am.
No. Oh, I see. Okay, let me share it once again. Just let me share. It's saying connecting. Just give me some time. Maybe the network is just 1 second. Just it says connecting. The network is quite okay. Or can I share the presentation with you in case there is a problem? Let me try. I don't know if the video, I'm keeping the video off, maybe in case the connection is not good. Let me now share it. There is some problem. Click share to share content. Yes, I have done that. It says connecting. Okay, let me send this PPT as well. In case I'm not able to show, I would request you to project it so that we don't lose on time.
When you share, you have to select optimize for text and images, ma'am. Then
Okay, is that so? Okay, let me. I have in fact done that.
yes,
Uh, just let me check that once again. In fact, that optimize for text and images is not showing up. It is grayed out,
okay, okay,
and yeah, that's the problem. That's why I'm preferring to maybe send you that. Initially, it did show up, but when I
okay.
shared it, you people are not able to see. So let me nevertheless share it with you, just in case, so that you can project it. Okay, I have sent you my slides. It's 3.4 MB, so maybe I think you can just check it. I'll nevertheless try again here. I've sent you the slides, Dr. Shakti. You can just have a look at it.
Yes, ma'am. Yes, ma'am. I'm sorry.
I would request you to please project it because here both the options are not coming up for
Yes,
me.
ma'am.
Yeah,
Yes,
it
ma'am. Yes,
continues to say connecting. Maybe the network is
ma'am.
bad.
Yes, ma'am. Ma'am, you sent to which email, ma'am? PSC cash mail
I
ID,
sent it to the
SAKDSA.
email that you sent me the link, no, for the talk.
Yes,
Link to
yes.
Atal AICT. That
Yes,
email I
ma'am.
have sent. Did you receive it?
Yes, ma'am. I
Yeah,
received now.
sure, sure.
I'm going to see.
Okay, wonderful. I can see it.
Is
I
it
hope
fine,
others
ma'am?
are also able to see it. Yes, I'm able to see it. Yes. So you can go directly to the second slide. Yes.
Yes, ma'am.
So Dr. Shakti, kindly move the slides for me. Thank you. So today I will take up in the, let's say, the next hour and a half or so on the relevance of where we look at product development and process development, particularly those coming out of R&D. And how do we see the relevance of different forms of intellectual property that we know relevant to the work that we do. Now, the second most important thing along with that is to understand that innovation is good. Turning that into an invention when it comes to patents is important because then we are looking at formally seeking property rights. So, as a institution, or let us say as a laboratory, or let us say as a project head, as a supervisor, how can you look at the enhancing the IP value in terms of the disclosure process so that we can go for early filing? It is not only important to file for patents, it is also important to look at the value of it. A jewelry in a safe has no meaning if you're not using it. The investment value of jewelry is different. The use value of it is different. Now, intellectual property is far more valuable than real property. And therefore, today, when we discuss intellectual property as a group, as an institution, not only that, as a country, we are all ranked by also the number of IP that we generate. So, therefore, leveraging the value of intellectual property is also very critical. Now, if you go to the next slide, next slide, please. Could we go to the next slide? Can we go to the next slide, please? Yes. So I thought the earlier one, please, the earlier one. Yeah. So for long, I have been thinking, where is the relevance of IP? And then I came up with this particular picture. I would request people to be kindly on mute so that we can have a good deliberation. Mrs. Shamina, requesting you to kindly mute your mic so that we can have a good deliberation. Yeah, thank you. Yeah. So for long, I have been deliberating on what is it that is making IP such a big difference to our lives. And today I realize that from rise to rest, we are using IP, and that's very true. Because today we have got used to comforts, we have got used to the use of different products compared to the times in which we were not using so many. Whether you call it convenience, whether you call it necessity, intellectual property is all around us. And so, therefore, I created this slide very recently, about a few months back, to bring home to us that we are actually using IP routinely. The next one, please. Next slide, please. Next slide, please. Next slide, please.
Is it okay, ma'am?
Yeah. Please go to the next slide. Next slide. Yeah, this slide, yes. So now then, if intellectual property is all around us, again, I'm requesting Mrs. Shamina, kindly please put your mic off. Can someone please...
Ma'am, I've muted. You can unmute your mic and speak.
Now, that is one scenario where we are looking at IP being a routine part of our life. Then the question is, are we paying for IP? Yes, we are paying for IP. Now, suppose I tell you that today there is going to be a mobile which is as good as one of those brands, but is only going to cost you 500 rupees. Wouldn't that be a great proposition? It would be a great proposition. Number one, it will be better affordable. Second, many more people can actually use the phone. And then, of course, we know that the mobile phone has now also become part and parcel of our daily wear. It is no longer about we wearing something which is very flashy in looking. We are more particular about whether we are carrying a mobile or not. So that is what we see as the disruptive value of technologies. So today, the research groups or individuals in research groups are beset with the basic problem of, should I be one in many or should I be one among many? Which trajectory will you choose depends on how you are placed in that ecosystem and what is the wherewithal that you have. Sometimes it may be good, you need to be looking at positioning yourself as one in the many. Now, all the blockbuster patents are about one in the many. All the lead technology based patents are all about the one in the many. Today we say 5G, 6G. So people are quickly moving with patents as property in order to take the place in that technology, hold that technology in form of property rights. So one in many is one context. The other is one among many. Now today we know, suppose you want to purchase something. Traditionally, we go to the shop to purchase, right? But today we actually go online either it is Amazon or something else, we are purchasing from there. Moreover, we now have also online based delivery mechanisms which promise you that within 10 minutes we will reach your doorstep. This is what, there are many like that. There are many like that which cater to this particular segment. There, it is a level playing field. They are also there, you are also there. That means the opportunity is such huge that there is place for everyone. So it is important to choose the trajectory. You may be sometimes one in many, sometimes you also look at one among many. Now, for all of this, we need to understand that we need to now work on what is it that is the strength for us in our R&D. And that is obviously shaped by the projects that you have, the R&D objectives that you have. Now, each of us are part of a research group. How often do we think outside the research area? How often do we think that, suppose I'm coming up with some particular, let us say, I'm concentrating an enzyme and I want to really have a substantial you know purity I want, and not only that, I also want to explore its activity. Are we looking at the native value of that enzyme in terms of its activity, or are we looking at why not use this enzyme in a different context? So, how often are we looking at across areas? That is important. Now, it is a very important dichotomy that all of us face in the research organizations, that today we are empowered with a lot of knowledge. We have lot of documents available over the internet. Click of the mouse, you can get research papers, you can sift through, you have databases which can organize the information for you, but the level of innovation is not adequately enough to the amount of information that we already possess. One, possibly because we're not looking around to address solutions for the problems that are there. Number two is that possibly we are not contextualizing our research with respect to what can be valuable, what can make a difference. The moment we do that, then comes the ability that we are actually innovating. Now, from innovations is where we see the remarkable changes which crystallize into inventions. So, it is important for us to incubate that process in the research and development, scenarios. So often we do come across, students who come up to us and say, "Look, I have done something. I believe this is very valuable." It is important that even if it's going to fail in the future, incubating that, fostering that, motivating that work to be done becomes important, because not all of us have achieved success without failing. So, therefore, failure becomes a very important step in order to achieve success, because your failures will someone will work on, or rather, you may be working on something which failed and you're trying to come up with a solution. So, we really need to look around and understand what are the problems existing for which maybe we can come up with solutions. And remember, even the courts today have become very sensitive. Courts are also saying that inventions need not be very, very highly technologically advanced. Even simple inventions can exist when it comes to patents. So, therefore, this is something that we need to really appreciate from the perspective of an R&D. So, you need to choose the trajectory on where you want to be and where you are actually looking at solutions. Yes. So, next one, please. Next slide. Therefore, when we look at a research and development process, obviously we are interested in knowing what is it that we can appropriate as property rights. Let us say I'm coming up with an invention. The other day I was just wondering that, all of us eat vermicelli. All of us have Maggie. This, all these different brands. So somehow vermicelli has become a very important part of the diet, isn't it not? I mean, earlier I believe this was not the case, but today vermicelli has become a very important part of it. Now, what about vermicelli comes only in certain particular size and shape? Is there any innovation possible for vermicelli? Question to ask. Now, if vermicelli has to be cooked, now, so are we looking at very big examples? No, not necessarily. We are looking at even simple examples where we can cut down on the number of steps, where we can cut down on the cost, where we can make innovations and turn into inventions which are better suitable. So this is the context that we are actually looking at. So I was just grappling with the thought of how come a 12th class student can come up with a design which can make wonderful changes to agriculture, and how come some of us who are actually from the agriculture background never thought of it. And this is true, let me tell you. I saw this online website called devitex.com, in which a 12th class student has come up with a device. He has a design right over it. That is a farming community. And it is nothing but, I wouldn't say nothing but, I'm not dismissing it. Let me tell you, it's a wonderful invention. It is actually a seeder. I mean, it can be used as a seeder. It can be also used to simply do interventions with respect to plants in a row. But a wonderful invention. Now, therefore, we need to now really look at where is it that we see the strength in our individual work as well as in the research work that we are doing. So, it is also important for us to know what are the different property rights that we can take when it comes to the area of intellectual property. Now, world over, there are certain forms of IPR that are recognized. So here we have 7 different forms of IPR. Some forms of IPR are highly technical. Some forms of IPR are predominantly non-technical. And some forms of IPR are about collective rights. They're about community rights. So we'll deal with that as we move forward. What you see on the left panel that I've written as informal IP. So today when we know the 7 forms of IPR, we call them disclosure-based IPR. And why do we say that? If I want a copyright registration, I should disclose that to the copyright registry. And subject to clearing copyright, I will get a registered copyright. So it is disclosure based. Suppose I choose not to tell anyone, then what is it? It remains as a trade secret. Now, the difference between a trade secret and confidential information is confidential information which is of tradable value or commercial value is what is trade secret. So as R&D units, it is important for us to safeguard trade secrets. Long years back, when IIT Kharagpur, the Dean of Postgraduate Studies, I was having a discussion. Since I'm also, I have a background in corporate sector, I suggested to the then Dean of the Postgraduate Studies, so, sir, why don't we have a record notebook? Because if we are capturing the know-how, or the trade secret part of it, somewhere there must be a documentation of it for 2 reasons. One is that you have to look at inventor and inventor rights, because inventors are coming up with inventions. Second is that sometimes we don't need to reinvent the wheel. If I know that the prior student has already worked on it, there's a lot of data that is there, and something went wrong, I can at least quickly look up that I have a reference point. So a record notebook is something which is imperative in organizations, because then the prior part of, before the patent, what are the steps you worked out or what are the product iterations that you brought in will be recorded somewhere, and it will be valuable for that laboratory as well as the researchers who are working in the area. So a good practice would be to have a good record notebook keeping. Now the question that you may ask for yourself is, does your institution have a record notebook keeping procedure? I Good to see Dr. Jansi here in this forum. She used to maintain a record notebook. When she was working with us at IIT Kharagpur, she's at another institution now. So it may be good for you to review whether, as part of your R&D process, are you having a formal record notebook keeping procedure rather than just writing some notes in some long notebook. What happens is that laboratory will have a series of those record notebooks which will have having important invention information, and that will be very useful in cutting down the time. Remember, resources are very limited now. We no longer have the generous funding that we can enjoy for, let's say, so many number of years. We have to work in a network mode. There's a lot of pressure on the R&D labs to, utilize funding has come down. So this is something that I thought I should let you all know. So protecting trade secrets is important because as yet in India we do not have a law. The procedure, there has been a discussion in terms of what should the trade secret bill be. Unless it is enacted, we still are yet to have the trade secret law. So this is one facet of it. Now, when we come to disclosure-based IPR, we need to really look at what is the relevant IPR that we are dealing with and the value of each of those IPR. Day in and day out, you're writing in your notebook the research results, right? You're generating copyright every day, every day. Now, let us say you come up with a very unique protocol. Okay, that protocol can be licensed. That protocol can be licensed. So, copyright can also be very valuable. Remember, copyright, when we talk about, people typically think books, literary works, artistic works, architecture, all of it. That is one facet of it. Sculptures. But remember, copyright is very, very relevant to R&D units, which are even biotechnology units, biochemistry departments, science departments, tech engineering departments. Why? Because suppose you're generating a protocol for doing something, or a machine, how it works, more optimal working, that manual can be copyrighted. And when you look at the copyright registry website, you will see a lot of registrations in this area. In fact, I have a copyright because I have created a book which is a patent search workbook, which is available as part of the NPTEL search. Of course, we've dedicated it to the public, but there is a resident copyright by way of its creation. So, therefore, copyright can be a very interesting way of doing it. Now, very recently, one inventor came up who is a professor and said that they have come up with a very interesting way in which treatment can be done, which is very relevant for this workshop. They have a particular way of using polarity, for developing, let us say, a wellness thing. And they've now done these studies and they've come up with a particular protocol. The question is, can I now take the protocol as a copyright? Perfectly, yes. One another professor from the architecture department came and said they have come up with a model for smart city planning. And that has been implemented now in one of the states. What did they do? They didn't go for anything else. They went for a copyright on the model. So therefore, copyright can have a big value with respect to IPR. Can we move to the next slide, please? Next slide. Next one. Yes. So I've talked about trade secrets. So it's very important that we keep the negative data as well in the documentation. So as a good practice, do not strike off completely any of the negative data, because today what we know as a post-it has come out of negative data. So therefore, remember, we're paying for a post-it, and that is completely come out of negative data. So therefore, this is the value that we need to really look at when it comes to trade secrets. Next one, please. Next slide. Next slide, please. Yes, copyright. This is what I was talking about. Now, very interestingly, as I told you, these are the different copyrighted works, right? Literary works. Then we have artistic works, sculptures. We have dramatic works. We have cinematographic works. Now, so let's say we are an R&D unit, dealing with coming up with processes, products, and all of it. And today people are also looking at interventions of computer programs in biology. Let us say you're coming up with a database. You've created n number of probes and you came up with a database where you have the sequences of it, the functions deciphered, and then you can mix and match probes and all of that. Let's say you create that repository. Can that repository have a copyright? Yes, perfectly. You can go for a database protection under the copyright registry in India. This is one part of it. Now, in the area of biology also, people are coming up with the applications, AI based applications, software applications in the area of biology. All of that you can also take the copyright with respect to submitting that in terms of the database protection. So this is one part of it. So today copyright has gone into several different realms when it comes to the area of, I have a database that I have created for agriculture invention resources in India. I have a copyright on the database, that registered number. And copyright, you can file it yourself. If you know the procedure, you can actually file it yourself at the copyright registry. And if it is there is no existing similar one like that, you will get a registered copyright in a very short time. So this is one facet of it that we need to keep in mind. Now, increasingly, people videos protocols, but they want it in the video format. So is the video format going to also have copyright? Yes, it will have copyright. Now, there are many institutions which have created their own ERP solutions. That is how they manage the workflow in their organizations. Is that ERP? Can you have a copyright? Yes, perfectly. You can have a copyright. In fact, in our institution, the ERP was developed by a person from the staff. He has a copyright. Now, the IP activities that we undertake in our institution, we created an IP portal. Now, that portal is again copyrighted. Interestingly, what is the value I told you, right? I told you that little later in the talk, I'll talk about the value of intellectual property. Remember that IP portal we have a copyright on. That one of the banks in the country has asked that we want to see how you have developed it. Can we take a license on that? So when you started the tool, you had not envisaged the value of your property. You developed it, took the copyright. But look at the value generation now. So therefore, realizing the value of copyright is also very important when it comes to work in relation to biology, where you can have databases, and then also you can have programs which are dedicatedly developed in this particular area. So can we go to the next one, please? Next slide. Yes. So now we come to the second form of intellectual property, which is typically relevant for business units. Most of the time, it is also relevant for institutions, but often we use trademark in relation to trade. It is very, very important for startups to at least go for a trade. So often when startups come to us that, look, we are developing this technology, we are now grappling with funding and we are coming up with this, we tell them that, okay, patent filing, maybe if it is not ready, you don't file that, but at least your name of the company, market, trademark it. Why? Because when they're now looking for investment, they have to go with under some name. They're looking for funding and collaboration. Then again, they have to look at, okay, what are they known by? So creating a trademark becomes very, very important from that particular context. So registering a trademark means what? It is indicating the source of that particular concern. So trademark works like an indication of source. So if I say, let us say if I'm talking about Yahoo, immediately it will come up in your mind that Yahoo is a website. So let us say Google. Google is a trademark, and then it immediately rings home to you that what is Google for. So trademarks are very relevant from that perspective when it comes to the business, particularly when it comes to goods and services. So if it's a service mark, it is represented by SM. If it is a trademark, you need not register trademark. Unregistered trademarks are also available. So suppose you want to quickly go to an investor, to get some funding, and you are a startup. You have not yet registered your intellectual property. Simply you use the name and as a superscript put TM. So that is a constructive notice to people that, look, you are using a trademark, but it is not yet registered. So with that, if you go to the trademark registry and make an application, the trademark registry may approve of it, in which case it becomes what you see on this slide, a capital R in a circle. A capital R in a circle is for registered trademarks. So we have had some very successful startups who do not have patents, but they have very successful trademarks. And remember that it's very interesting that sometimes you need to also avoid infringement. So when we come to the area of trademarks, it is also important to search for whether there is an existing mark and avoid any overlap, because the distinction of the good and the source obviously will be confusing if it is an overlap. Therefore, it is important to look at. And trademarks are relevant to all different areas: technical, non-technical, bank sector. I put LIC on this slide. So it tells you what is the good immediately when you see the mark. And today, Blinkit, what else? Did you ever think that you will use the word Blinkit? When you say Blinkit, we normally say blinking of the eye. Can you imagine someone has now used Blinkit as a trademark? And today, all of us know the word. So there's something, therefore, trademarks have a lot of value when it comes to organizations. Now, there are two categories of trademarks, which the law also recognizes a hierarchy in that. There are well known marks and then there are trademarks. Now, well known marks are well known across jurisdictions. That is FedEx, Google. Okay, whether or not Google is operating a service unit in India, when you say Google, we know that Google relates to that. So there are some trademarks which are actually transboundary in nature. They are well known across countries and across the particular. So therefore, they are well known marks. And then there are also marks in general, which are the trademarks. Now, in trademark, again, we have a lot of category of marks. We have associated marks. So you have Reliance, then you have Reliance Fresh. When you say Reliance Fresh, immediately it tells us that there's something possibly about vegetables, right? So those are associated marks. Then we have collective marks, business houses, Orange County. The moment I say Orange County, it will ring home to you some tourism and all that. You say, so that kind of thing. Now, recently, just day before you saw in the paper, they talked about Wow Momo and Wow Burger. So Wow Momo, everyone knows the color, the black, this thing, and everything. It is Wow Momo. Very good. Now, someone has come up with a Wow Burger. So immediately, Wow Momo has soon sued the people and said that look, they are using Wow, and they should not use Wow, because Wow Momo, we are, the Wow with Momo is what is distinct about us. Now the court ruled in the favor of Wow Burger. Said Wow is not a word which is to be captured by everyone. It is a common word. You have the trademark Wow Momo, which is fair enough. Wow is a common word which is there for everyone. It is common as part of public domain. Wow Burger is perfectly fine, because Wow Burger, when you say, it is burger. Wow Momo, when you say, it is Momo. So when there's distinction of products very clear, where is the question of infringement? There is no overlap. So court ruled in the favor of. So you do see a lot of these scenarios. There was a case of Infosys versus Infosys. Very interesting case. Infosys, all of us know, but many of us do not know. Infosys is a BPO in Delhi. There is a small unit which is a BPO in Delhi. So when the case of Infosys versus Infosys came up, then the court also said that if you say Infosys, people know which Infosys they are talking about. In a smaller circle of that area, if you say Infosys, they know it is a business processing unit. They know that Infosys does not mean the Infosys which is there in Bangalore. So therefore, court has also looked at these kind of things. So trademark is a very prevalent area when it comes to a lot of litigation. Trademark is also very important today when it comes to startups, because startups are known by the name. So we have had a very interesting startup which is based on nanochemicals. So and then the trademark somewhere also signifies your persona into the mark itself. So the startup said, look, I am very good at chemistry, and I want chemistry part also to be part of this trademark. So we said, okay, fine. So some benzene rings with numbers had to be prepared along with the trademark. Suppose you have only benzene rings, it will not be distinctive. In the benzene rings, we actually put the name of the company, and that's how the mark got registered. So trademark is again a very important area when it comes to the this thing. So symbols are also. So you have a database. Let us say the database becomes vendable. You are licensing it. The database is known by some particular name, some symbol that you can go for a trademark. So therefore, you can have multiple protections available on any certain type of product. Can we go to the next one, please? Next slide, please. Okay, so now we come to the technical side of intellectual property rights. Patents are given to inventions, and inventions come typically from the research and development. It is not to mean that inventions cannot be done at home. There are a lot of frugal inventions in India where we see people have actually done it at home. So inventions are actually what are the subject matter of protection when it comes to patents. There's another IP which is design. So patents and design are highly technical in nature. They arise out of different areas of technology. So whether it is biochemistry, biotechnology, mechanical engineering, metallurgical engineering, materials engineering, what is it that we are looking at? We are looking at coming up with different products and processes in the R&D. Okay, so that which arises out of the product of technology, processes involved with technology, is where we are looking at the protection. So let us say I have purchased a machine, okay, which is, let us say, coming from Germany or from US or wherever that is, or maybe an Indian manufacturer has prepared it. I have purchased that particular machine. Now what do? I just open up all the parts. I understand how the product, what are the components, and now I re-engineer the product because I know it, right? So then what do? I see a good opportunity for making a business out of it. So the re-engineered product, let us say, I start selling several units in the country and I put up a big shop. If the person who sold me did not have a patent right, then he cannot bar me from making the product, right? I can assemble it very well, not a problem at all. But suppose the company which sold you the product has a property right in the form of a patent, then any re engineering of it, any making of it will mean you're trespassing on their property, which means you're infringing their property. Do you realize why it is important to secure patent rights? Suppose, let us say you came up with an invention, you went to a conference and you spoke about it. Quickly, someone has modified the invention and filed for a patent. If they file for a patent in India, they can bar you also from working in that area. Why? Then you cannot claim that, look, I was already earlier working in that. Why? Because they would have already modified it. On the modified product or process, they have intellectual property. They can come down and simply bar you from making the product. So patents are property, and if they are property, they actually have all the notions of real property. If you have a land and someone trespasses on your land, would you allow that? No. So, do you realize the value of what are patents? Patents, when you have on inventions, you can secure property rights. What does that mean in the real sense? That you can now make it available for permitted license. So, suppose, let us say, I come up with an interesting invention, okay, where I have come up with a product. And let us say I secure property rights on that. Then what happens? No one else in this country can make that product or use that product or offer for sale. Why? Because that is my property. And because of that, what will happen? People will need to come to me to take a license. In a permitted license, I can actually permit many people on a non exclusive mode to use my product, make my product. I can earn revenue out of it. So, this is where we see the value of patents when it comes to the property rights. Second important thing is when we come up with something which is an important product, something which is a useful process, we are also looking at the public perspective, that you are gaining the reward of intellectual property rights in exchange of what? The information on the invention. So patents serve for the purpose of creating property rights in relation to invention. Now, typically, most R&D units, typically we face the problem of one big bottleneck that we find is in the prior to the invention filing stage, because it takes a while for it to be disclosed within the institution and then get ready for the funding for filing. And if you're filing and only filing only, then it is not going to help. You have to get the patent examined as well. So understanding these procedures also is adequately important when it comes to patents. What you see on this particular slide are some of the very old patents, but then these have got property rights. I would ask a question in this forum: how many of you are looking at expired patents? Please note that there is a link called expired patents at the Indian Patent Office website. And why am I emphasizing on this? If you look at the expired patents website link, you will find all those products and process which are expired in terms of property rights. That means they are available for us to modify. Now, let us say you modify, you come up with the next invention, you can file for property rights. So, this is something which is very valuable. And this is such an important area that even big companies actually hire people only to look at how to break patents of others and how to modify patents and how to really look at expired patents and then modify it. So, therefore, this is something we ought to also realize from an R&D perspective. If you are not coming up with something upfront in terms of making a product, at least existing products which are not under protection, can you modify that or can you make it available in a better way for current use? And most times we do see inventions in that area as well. So we can go to the next slide, please. Next slide, please. Okay, so I talked to you about patents. Patents are technical in nature. Now, the law also comes up with the definition of an invention. The definition of an invention is something which is a product or a process, ought to be new, first of all, fundamentally. So, I cannot come up with old products and go to the patent office and say, look, can you give me a patent on this cup? No. Unless the cup is novel, you will not get a patent. Now, need not only be novel, it also has to be inventive. That is it that you have made a change of the cap of the bottle from green to red? Yes, it is novel, but it's not inventive because it is easily envisageable. So patents have to be novel, inventions have to be novel, they also need to be inventive. Now, in India, we have the good advantage of what we call economic significance. And that economic significance can typically be utilized well to come up with some very simple inventions, but which can have a lot of value when it comes to the public space. Since we are discussing medical innovations in this workshop, I just wanted to allude your thinking to one particular area. So for long, a few of these researchers in the Affordable Healthcare Center were looking at, see, when the infant is born, the infant is taken from the bed to the weighing scale, right? Beside the bed. And then the weight is taken and it is recorded at the time of birth, which is the typical process. And then there are also certain other medical scenarios where the patient cannot be lifted from the bed in order to take the weight of the body. So thus that is the problem that the inventors were working with. Now inventors came up with a scale which will determine the weight of that infant on the bed itself. So some of us may be thinking that what is so big about it? We thought about it, but we have not worked on it. They thought about it and they have worked on it. And what is happening as a result of that? They have come up with a novel product, and that novel product is very simple. They are able to very effectively calculate the weight without even having to. And remember, I was myself also quite shocked that, oh, this is something which no one has worked, but they have worked on it, worthy of filing of a patent. And today, it is a filed patent application. So, so there are several of these, areas. Now, there was one student who said that why not we use kajal as the means of delivery mechanism? Isn't it? This is very interesting, right? So everyone is using kajal in the eye, right? Women are using kajal. So she said, I will use kajal as a mechanism of delivery. Sounds very usual, right? What is there so big about it? But she has done it and come up with a very, very important delivery mechanism when it comes to certain medical inventions. So this is something which is very interesting, and especially those, I've had the good fortune of, I mentioned to you about her in this workshop, who is very innovative in terms of looking at materials and the value of materials. So use your strength in the particular area to come up with inventions which need not be something which is high tech. It can be very, simple, but can make a big difference when it comes to the medical area. So yes, can we go to the next slide? I think the slides are off the. If you can project that again. So I was talking to you about designs as the next other form of intellectual property. Now, what is the difference between a design and a patent? Design is just the overall appeal. Ornamental appeal of a product is a design. So when we say design, often we look at perfume bottles. More than the perfume, people are interested in the bottle shape. Now, another area where design has a lot of value is more than whether the bag is made of leather or it is made of cloth. We're interested in the shape of the bag, right? Shape of the bag, color of the bag. We're interested more in those kind of things. Similarly, when it comes to the area of, let us say, crockery or fancy items, we are more interested in the overall look of the product. Now, design caters to the overall look of the product, and therefore, design is non technical in nature. It is non-functional in nature, sorry, not non-technical. Design comes from, again, a technical area, but it is non-functional. So let us say I am looking at a water bottle. We have typically these plastic bottles, right, where there is grooved material, right? Now the overall shape is a design. Overall shape is a design. The ability to hold it in a particular way is functional in nature. So a bottle can have a design, registration. It may have another intellectual property, which is even a patent. The process of making the bottle, assembling that product, is a functional part. That is the patent. Just the look of it is the design. I hope you are able to get this. Can you please project the slides? I don't see the slides coming up. Or let me otherwise try to share. Are the slides visible to all of you?
No, ma'am.
Oh, I see. I think somehow there's.
No,
they
ma'am.
have not.
No,
I
ma'am.
will request the organizers to please share the slides, because even I am trying now, I am not able to share. It doesn't come up. Dr. Shakti, I think you are there. If you can
Now
please
it is
share.
visible. Now it is
It's
visible,
visible.
ma'am.
Okay, it's visible. Then that's good. All right.
Visible, ma'am.
Okay, then I cannot see the slide, so I will request that you can. So now, so what you see on these slides are designs. See the various designs. It appeals to us because when we go to the market, we are looking at certain designs, especially toy industry, household articles. We are not just interested in the functionality of the fridge, refrigerator. We are interested in the look of it. Therefore, that is where again designs have a lot of value. Now, in the next slide, what you see is the difference between a patent and a design. I have taken an example of a fan to illustrate to you what is the difference between the design and the patent. The patent is on the functionality, how the blade rotates, how the blade function is in cohort with others, how the fan runs is the patent. Only the look of the fan is what is the design. How you engage the umbrella, that mechanism is a patent. The look of an umbrella is a design. So that's essentially where we need to look at the patent and design. Most often, we don't go for patent protection. We go for sometimes even design protection. Why? Because if the novelty value of the technology is low, we shift to a design registration. We have done that in many cases where people have come up with a solar dryer. Yeah, this is the example I was talking about, the distinction between a patent and a design. So I listed to you one another example. So there was this professor from one of the departments who came up with a solar dryer, solar mechanism, and they came up with a large tank, more efficient, all that is fine, but somehow we found a lot of the prior patents in the area where it is very close by, the inventiveness is not that high. So we said that I think most likely the design may be a better registration in terms of the patent office compared to a patent. And anyway, the design was actually for small and marginal farmers. And so therefore we said a design registration is quicker. If the examiner is spending time on 10 patents, the same examiner will clear 20 designs in one go. So the workflow is much simpler when it comes to design. So it depends on actually what you want to actually look at in terms of securing the IP right. So this is where we see the value of designs. And in the current technology areas, see, for example, let's say you have a 3D printer. Now, I had this very interesting presentation which I was reviewing, where they came up with a 3D design. They were coming up with, some material part of it, and they've designed something and all that. But we found that the design itself is very interesting. The functionality is anyway good. We said, why not go for even a separate design, right? So therefore, these facets come in. So design is not just about cup and saucer, but today 3D printed designs. Design is a dedicated area that many people work on, and so therefore one can actually also file for designer. Today, what we see as the photocopier machine, all those are also designs. Agriculture area designs, horticulture area designs. Every industry is also have design. Jewelry industry, they have designs. Fabric industry, textile industry, they have designs. Today, what you see as designs on the web when you're purchasing certain apparel are protected under designs. Some of the famous the designers, so-called designers, they all have design rights on the apparel. So the law also recognizes what is called set of articles. So suppose I say earrings and the necklace, that is one set. Cup and saucer is one set. So they cannot be sold separately, they'll be sold only in that particular format. They're called set of articles, which again the law recognizes. And very interestingly, we have now gone into a very newer dimension of design. If you look at in the other countries, the way you set the food material, let's say you go to a big restaurant, right? The same curd rice, on that they have a topping, and let us say this is what is their signature. Even that can be taken as design. In fact, they have signature designs on those. So this is something very, very interesting when it comes to now video games are a complete facet of the underlying technology to develop the video game, it looks very nice in terms of the design. So today we are looking at the various facets of it, the GUI interface as a design. So these have become very important in terms of technological interventions and designs as well. Virtual designs, looking at online content creation of designs and all of those. So therefore, those are something which we are looking at in the current technological domain that we see, pervasive value of designs. The next one, please. Okay. We look at plant variety protection as another form of intellectual property right. This is relevant to what? This is relevant to uh, all the units which are working on agriculture, those which are working in the area of biotechnology, industry which is in the area of agriculture, uh, biological, life sciences, and biotechnology area. So, plant variety protection secures intellectual property in relation to improved varieties of plants. This is one context. The other context is plant variety protection also takes care of what is called recognizing existing varieties also. So, this is one peculiar form of intellectual property. In other cases, we said novelty is a requirement, right? But in this case, in one particular area, we say improved varieties will get plant variety. That means breeder material. Suppose I have bred a rose variety, that improved rose variety, I can go to the Plant Variety Protection Authority and seek a plant variety protection right. Now, I've genetically engineered, let us say, I've genetically engineered, for the sake of discussion, let us say what you see, brinjal. Okay, genetic engineering of brinjal, is on hold in terms of the approval as a plant variety. Why? Because it has to additionally go through regulatory laws, the GEAC for approval for the field release. So, genetically engineered uh, uh, plants material also you can get plant variety protection, and that is what is called essentially derived variety category. Suppose you do mutation, you have, let us say, large orange that you have created. That improved orange is because of mutation that you've deliberately brought in. That mutant variety is eligible for essentially derived variety registration. So we do have a lot of improved varieties registered under the Plant Variety Protection Act. We also have land races. What you are in Coimbatore is very close to Kerala. Some of the rice varieties, Ponni is what you're using. Ponni is a farmer variety. Now, Ponni is being, crossed with something. Those are hybrids. Those will become hybrid varieties. So we have farmer varieties. Pokali. We have, Kalajira. We have Adamchini Chawal, Ambe Mohar rice. From different areas when it comes to these are farmer varieties because they are actually natively farmers have been cultivating that since generations. So the farmer variety also are recognized under the Plant Variety Protection Act. So this is a legislation that is useful when it comes to improved varieties, and this also again may be relevant for a lot of work that agriculture. So if you are working in the vicinity of an agriculture institution, it may be good for you to look at working with them and collaborating with them. So, is it that agriculture universities are only looking at plant variety? No. If you're developing new processes for agriculture, new products for agriculture, again, you can go for patent protection. You can come up with designs. So, today, the area of agriculture needs a lot of interventions because we are talking about precision agriculture, use of AI in agriculture, whatsoever. Agriculture also, we need solutions. And so, therefore, that is another place where we need to look at. I'll give you an instance of it just to motivate some of you who are there in this forum. Now, in India, we have a lot of rice varieties, right? Rice varieties, which are also regional in nature. For example, we talked about Pokali, Ambe Mohar, Adamchini Chawal in UP. Here we have Joha in Assam. We have again Govindabhog Chawal in the case of West Bengal. I know all of you are from several different places, so I'm just deliberately taking examples of that. What is the problem with the Govindabhog rice or the Adamchini Chawal and all? Now, farmers are tending to take the hybrid seed to go forward for cultivation. So the traditional rice varieties are under a lot of but are under a lot of stress because traditional rice varieties don't yield that much but have high medicinal value and are also good for health. So there are some solutions that you can think of. Can we have better packaging of these rice varieties so that it can go for export? One question to ask. So, can you come up with a packaging material which is patentable and that can be useful for exporting this GI rice in a better way? Or can you come up with better agricultural practices or easy agricultural practices so that it can help the farmer also grow these GI rice varieties? Good question to ask. But solutions are needed. Now, can we have innovations to the supply chain? So, can we have better management processes which are technical in nature, which can help farmers understand? Like, I give you one practical example. In many areas, there are no mills. So, what they sell off as paddy, they don't get the value as farmers. Suppose there's a milling unit, then you can you can get the rice, and the rice will have far more value than the paddy itself. So now the farmers are simply asking, can you have a milling unit? Now, I visited the Madurai Agriculture Business Foundation. I found a very interesting example from there, that they allow the nearby farmers to come to their unit and put it through the milling thing. They get the rice, package it, and then they go and sell it. So, in your institution, what is this? Can you address some of these problems to the nearby farmers? Maybe your nearby farmer is not having a good harvester. Can you come up with a better harvester? Plucking fruits is a problem because they get damaged. Another thing is we are not able to harvest in time. Second thing is we are possibly the it is not so ripe, we are harvesting that material. So can we come up with a sensor? At the same time, can we also detect that and quickly harvest them in no matter of time? Then farmer will be happy because quickly the farmer can go to the market. So supply chain is another area where we should look at a lot of innovations. So identifying that obviously is the first step. Let me tell you, when we work in some of these areas, we are also actively thinking. So I work on GI rice. When I talk to the farmers, I'm actively thinking of this is the problem, how to address it by developing a technical solution, how to look at the supply chain part of it. Can we have a mobile app for them which will tell them, that quickly this is the milling unit? Now, one of the persons during the COVID time came up with a fish mate. You can look up, fish mate is a trademark, by the way. Fish mate mobile application. Now, what is the problem that that person was addressing? That mobile application is an application of a software program with respect to aquaculture. Perfectly patentable. They have already filed a patent application and it is under examination. What is the solution that they're addressing? That fish feed is important in order to now develop the fish aquaculture. So, timely disposition of the fish feed is important. That's number one. Second thing, quality fish feed is also very critical. So, nothing. They simply developed a mobile application which will take the input data from several of these units which are supplying the feeder material, and that is now implemented in every of those units, and quickly they get to know if this is unit is not having it, next unit will have it, so they will source it from there. Simple application has tremendous value when it comes to the entire implementation in the social form. So we need to really look at some of those out of the box solutions. So can we handhold certain intellectual property? I mentioned about GI. Now there are a lot of plant varieties which are already available in the as registered plant varieties. Now let us say there's a mixture of germplasm. Is there a fast way of detecting that? We don't still have that. We don't still have that. Can I say from my saliva, this is my this is what is the DNA fingerprint? Do we have rapid diagnostics? We don't have that. Sometimes I'm beginning to, it seems saliva can be a diagnostic thing for several different diseases. Do we have a home testing kit for saliva? We don't have. We have a thermometer which can test temperature, but we don't have the a saliva diagnostic kit. So this is where we need to really look at innovations. Okay, so can we go to the next one? I don't see which one is being displayed. In fact, I am not able to see the slides.
Ma'am, PPT is not visible, ma'am.
Yeah, even I'm not able to see the PPT because they're projecting it from their side. I hope they could share it with all of you. I will request organizers to send it over to. See, another area where we should look at is, can I attach the PPT to this participant list? If there was a mechanism where I could just click on and attach slides, that would have been again a very interesting way of actually developing the innovation. So, can WebEx support attaching PPT? Next development. So, there are some of these things we should actively look at. Okay, I come to. I know we have less time on this, so quickly I'd like to move to the next set of slides. So, semiconductor layout design is another form of intellectual property. Now, this is something where India has a lot of opportunity to go forward. What is the value of this area? Value of this area is that it is related to chip. Now, what is the chip? That chip has a layering of certain technological components. I'm not going into the technology, connected in a particular way, achieving a particular function. So, therefore, semiconductor layout design again is technical in nature, subject matter. Now, because of it's a semiconductor, it doesn't conduct very high. So, therefore, the electrical burnout and all that will not happen. At the same time, it is not that it doesn't conduct, it is between high conductivity and low So semiconductor is all about that. Now, semiconductor layout design is a separate form of intellectual property. The layers itself are inventive in nature. The overall chip and its function is again inventive, because any protection which is like, let's say, copyright, design or patent cannot wholly protect the chip. A separate form of intellectual property has been identified, which is a semiconductor layout design. India is a member country to the TRIPS agreement, where TRIPS also recognizes semiconductor layout as one form of IP. India has also enacted legislation in this case also. We have semiconductor layout design 2000 act. Why is this important? In some other point of time, in a few years back, if I had spoken in a forum like this, we would discuss this only as one form of IP. But today, India has announced 2021 December semiconductor mission. Lot of the multinational companies are setting up their manufacturing units in India for this particular area. So soon we're going to come up with chips which are going to have function coded in them, and they will be used as a very important part of a device. The device will run on that particular chip. Today, our mobile device is nothing if the chip doesn't function, right? So this is the value of that chip. So this protection is typically for semiconductor layout design. This is one area where you can also see in future lot of registrations that are possible. And this is relevant not just for the semiconductor industry, please. It is also relevant for biological applications, where you have, let's say, chip based detection. Suppose, let's say, there is very dense canopy, let's say banana plantation that you're talking about, or even some other plantation where it is very difficult to go into the interior of the plantation to see the photosynthetic value or any of that parameters that you're going to assess. If you have a device which runs with this, it can independently take those parameters and simultaneously give you real time data. So the power of the chip technology actually is about that. In fact, many of the agriculture implements today have these sensor devices which will give you optimally the whether or not a plant is ready for any particular function, whether you call it pre-harvesting or the post-harvesting. I'll go to the next slide, please. Next slide. Well, I had a preliminary discussion with you about GI. Now, geographical indications are one form of IP, and here it is typically a community IP. All other IP that we have discussed so far, those are all person specific, individual specific, whether it is an individual inventor or it is a company. But geographical indications are given to community. It's a community right. So farmers as a community can have the GI for, let's say, a rice variety. Now, weavers as a group will have Coimbatore grinder is a GI as a manufactured GI. Okay. Now, there are several GIs which are now being registered in India. We have seen a remarkable registration of GIs which are products of India, which have either natural in nature, that is, let's say, Nagpur orange. Okay. We know it has a particular flavor. Or let us say, Mallige of, Malipu, the jasmine variety from, let us say, that is known for from that particular place, let's say Madurai or wherever that is. So that is because of the natural characteristics in that particular region. So therefore, it is a GI because it's a geographical indication. Similarly, we are talking about some sweet preparations. Okay, those are also GIs. Again, recognizing the raw material as well as the people skill part of it. Now, these are getting registered very fast, but the question of promoting GI is becoming a problem. So internationally, we are not able to get the value. Why? Because we do not have good packaging means. We do not have good promotion means. So there is again where we can look at innovations for packaging and all that. We can start looking at patents and designs, and those things are possible. So uh, I remember during the COVID time, it was a very interesting scenario with discussion that we had. So mihidana is that small bundi, bundi laddu we say, right? So that bundi. So the people who were making mihidana is a GI. So they said, Madam, we have a huge problem. What is that problem? We are pouring those heaps of mihidana, and during the COVID time, not many people are coming to buy. We can't keep this because shelf life is very small. So this entire thing is going to go a waste. So can we come up with a device which will tell us that this material will be now uh, good enough up to some particular, let us say, some stage? Are there ways in which we can store the material? Then again, it is better. So a lot of our GIs, we are not receiving domestic front also. We are not able to receive the value. Sometimes even internationally, we are not able to receive value because we don't have the intervention. These interventions can come well from patent area. So you can have a technological application which will help in the detection. So let us say they're using the date syrup. Suppose someone can come up with a technological application to tell us the status of the date syrup, but by when this is going to get fermented and it will spoil. That time point can be a very important time point for even the quality perspective of GI. So therefore, I'm just enthusing your thinking to see that can we now come up with technological solutions for GI for better domestic this thing as well as for uh, even the international food. One important area is counterfeit, especially textile area. See, Kanjivaram sari, exact replica you will find. You'll find exact replica a Chinese silk. You will not be able to make out. So, can I come up with a rapid device? Let us say a housewife is going to a market to buy Kanjivaram. Can she have a rapid diagnostic kit or a testing kit so that she can just put it on that and then she will get to know? So it may look very rosy to us when we talk about this, but that is where the starting point is when it comes to developing certain inventions. So these are what GI are. If you go to the GI registry website, you can find out how many GIs are registered in India and what is the current status of those GI. The communities are suffering because the communities do not have adequate linkages. So to build better linkages, can you come up with a good database which can help them sell better, which can connect them to traders? It's a technical solution for a GI. So therefore, this is something I would like to emphasize on when it comes to where we can look at developments. Next one, please. Quickly, I'll next one, please. Okay. So I've discussed with you so far about the different forms of IP rights. Now, obviously, you should be beset thinking that what is it that you can do, to enhance the IP value when it comes to your organization. The first important thing is to look for what are the problems to be solved. Are we doing something which we are only reinventing the wheel, or am I developing some solution to an existing problem that has been there since the time you knew about it? No one is working. Can you take that up? Then, what are the solutions that can be possible? Then how do we really look at the market perspective? See, typically as R&D organizations, we are not driven by market needs, but today we don't have the comfort of that. Today, when funding agencies are giving us the funding agencies are also interested in the outcome to the society. So is our process attuned to understand what the market needs? So that is something we need to really look at. Can we take advantage of digital technologies? Can we take advantage of network? Can we work in a collaborative atmosphere? And how well do we incubate the thoughts on IP? Are we promoting startups in our own organizations? And ultimately, we have to secure property rights. So we have to have a robust process of the capturing the initial stage of IP to actually realizing the value of IP. All of this is a very dedicated process, and therefore, all of us are part of it. It is not that just the inventor is there or only the IP cell is doing the job. It is actually has to be driven to that extent. So, do we have, even for us internally, do we have anything like a helpline for IP? Sounds very strange, right? Oh, helpline is only for someone who is in trouble. But do we have a helpline for IP in our own organization? That, look, I'm coming up with something. Does anyone have this material in some other department? Can you help me with it so that I can quickly turn over this and come up with an invention? So, do we have a helpline for IP? Question to ask. So, are we going to sit down on the web and look at who has the technology with whom I can collaborate? So we need to have a help desk, which will be a real time help desk. Suppose I punch in and says that, look, I'm now working on this. I need this machine from this lab so that I can finish the testing and I can go for IP filing. Do we have that mechanism? Why? Because we cannot afford the lag time. We can afford some time, but if there's too much of time to delay in the filing of IP, remember, you're securing property rights at a very later stage. By then, the world would have moved on. So, this is one fundamental question that we need to address. And we need to have a bit of a revolutionary thinking when it comes to IP. It is not the traditional IP cell will take care, IP in charge will take care. Every one of us is part of it. So, therefore, we need to give it a prime focus. Next one, please. Yes, this is exactly what I meant. When I said development to market should be simplified, people who are professors, who are researchers, cannot be burdened too much by going beyond their laboratory. Somewhere the thing should come up to the laboratory stage. If an inventor only has to search for the who is the potential buyer, then we have not achieved much. If an inventor has to run to the IP cell, we have not achieved much. Let the inventor spend more time in the lab. Let the IP cell reach the lab. Let the arrangement with respect to the buyer reach the lab. Then inventor will feel more comfortable working on it. Therefore, today we have to look at it a little differently. Yes, we have had great times of having IP cell, R&D units linking with the IP cell, filing mechanism, all that. But today we cannot afford the time. So therefore, understanding the needs and expectations, shared IP, project standalone, interaction with startups, all of this is a completely different dimension today as we see. Next one. I'm almost to the last part of my presentation. So we need to encourage startups because today that's the way to go. Quickly, we have startups, student startups, faculty startups, because today even the industry is looking for academic campuses for solutions. And gone are the days where industry, it was like you invite industry for an industry academia meet, exhibition. No, industry is deliberately coming. They're setting up their units on campuses. So we need to hasten the process of this, because ultimately we have to become less dependent on imports. Our import dependency is extremely high in the country. If we have to reduce the imports, obviously we have to fall in line with the pitch of where we are self-reliant. And this self-reliance pitch which India has brought in is very timely. If we work now, we will realize the value of it obviously at some point of time. So therefore, we need to encourage uh, all the different types of firms, either into manufacturing, into technology transfer, into development, adoption, whatsoever that is. Next one, please. This calls for obviously a different kind of thinking. So we also need to appreciate the fact that inventions don't come only in laboratories. Inventions can arise from all corners. So if you see a laboratory, yes, that is a very dedicated unit. But suppose I see a crowd like that, what you're seeing in the middle of the slide, certainly that is a botheration for everyone. When you see a jam packed crowd, all of us start thinking, right? Oh, there must be a solution for this. How can I avoid this? And that is the starting point. So in the society, when we see, also we need to look at this. And at home, Inventions can happen in a very relaxed atmosphere also, because then also. So therefore, we need to look at catering for all of these ecosystems. I've known of a student saying that I've done this invention in the hostel. Give me a no objection. I want to file the patent on my own name. I am the inventor. I am the owner. So be it. If that is the case and that is the evidence available, we need to encourage that. That what does that mean? Inventions need not come only in the laboratories. So we need to cater to all the scenarios when it comes to that. So I've placed two or three scenarios for you on this slide, where today's students are bold enough. They say that, look, I want to go for a startup. Give me a semester withdrawal. I've also faced a scenario where one of my students in the semester one itself came up and said, I want to start a legal startup. I want to take withdrawal in the first semester. Very difficult scenario. In the very first semester, they want to take withdrawal. So academic regulations also need to become flexible to honor that. Some student says, look, I don't want to take placement. I want to withdraw. But if I don't do well in life, can I come back and take placement? We need to be flexible enough. We cannot say, look, oh, he was a student sometime, I cannot provide placement. You went and did a startup, and you that time did not participate. You never know what is the value that they can bring back to an institution. So that is something we need to obviously think of. It is not just about we as people. At some point of time, administrators will need to look at this, that when we are looking at outcomes of it out of an R&D, are we having this kind of a thinking that inventions don't happen only in the labs all the time? So if we are able to look at that diffused scenario of inventions, I'm very sure that we can achieve that. And most often the question that supervisors, some of them are in this meeting, I am also myself a supervisor, need to ask is, has your student come up with something innovative, or is it run of the mill? If the student has come up with something innovative, then that was the time worthwhile spent, let's say, on a master's thesis, on a PhD thesis. Unless we catch innovation at the root, we won't be able to translate IP, and certainly that IP will not get translated in the institution, and never when it comes to at the country stage. So therefore, we need to catch it very young, at the root of it, at the stage of, let us say, a registration seminar itself. What is innovative about your proposal that no one has done in the world so far? Unless we are attuned like that, our path towards creating IP may not be as much as the expectation that is there today. Next one, please. So we need to really look at early capture of IP, and this is exactly what this slide is about. So it is not about how many filings you have had. You may be a great institution with a record number of filings, but have you missed out on one student who wanted to go for a filing of IP but left the organization and got the IP in another organization? That means something went wrong in your organization where you could not foster the filing of the IP. Student had to go to another organization, and in that organization, they had the ecosystem to file IP. So it is not about numbers that we are looking at, but quality of patents, quality of IP also matters. Catching the IP very earlier on is very important, and it is here I would emphasize, there is not only the responsibility of the researcher, the responsibility of the supervisors, the lab, and the institutional ecosystem is as much when it comes to quick turnover on IP. Next one, please. Yes. So, in the midst of all of this, we know that every IP has certain criteria to fulfill. If I want a trademark, I have to fulfill certain criteria, then only I will get a trademark right. If I want a patent, I must remember that has to be a product or a process. It should not be against society. It should meet the requirements of what is called, it should be eligible under the law, it should be novel, it should be inventive, and I must particularly disclose the details. If I fulfill that, then there is a possibility that I can get a patent. Now, therefore, search is a very important step. All of us are searching for journal articles to know who has worked in the area. How many of us are searching through patents? How many of us are trying to understand that are there patents in my area? What are those different patents? What is the legal status of those patents? Maybe there is an expired patent that you can modify and then come up with a revolutionary invention. So patent search must be integral to every R&D unit. If you as a supervisor clear your student only when they have also done the patent search, then yes, step one you have achieved. You have made them more patent aware. they are conducting also a patent as a prior art search. So we are searching for non-patent literature. We are also searching for patent literature. In fact, that is a good step to ensure that we are working something on something very novel. So novelty, capturing novelty is very important. So anything before the invention is what we call prior art. So searching for journal articles, but also searching for patents is a good practice. And this is typically what happens most often in the industry. It also happens in educational institutions. We need to enhance that process. Next one, please. Since I'm exceeding time, I don't want to, I'll quickly come to the last setup. So we need to appreciate the fact that we need certainly high technologies or high definition, as I call it, but we also need redefinition. We also need to look at something which we can make a small change is better adaptable now to the society. So we need both. Now, we also need to look at how often are we promoting the culture of intellectual property rights. So do we have an IP culture in our lab, first of all? And then if you have it in your lab, do we have it in the institute? So do we reward our students if they have patents? Do they come up onto the stage and then you recognize them that look, they are inventors? And do we recognize our faculty who have got patents? Do we have a circular or a monthly newsletter which tells us that this month these are the patents filed and these are the inventors? Now, if intellectual property process is such a dedicated process of filing, investment, R&D and all of it, how come we are not recognizing in a monthly newsletter the inventors of our own institutions? So these are questions that all of us need to ask when it comes to every institution, irrespective of whether we are, higher education institutions or not. And are we encouraging creativity in our routine activities? This is something with unconventional thinking, entrepreneurship mindset, then research, ability to take up research. More often, because of AI or software and all of these areas, people don't want to do a PhD. What will happen to the area of IP? Question to ask. Then digital area, where we do have disadvantage, but actually presents a lot of advantage. How can we use digital area for better innovations is one something which we need to. So obviously, with all this, good word said, institutions have several challenges. Today, institutions are not the same when we see in the times when we did our PhDs. There's a lot of burden institutions have, and it is not an easy task for any institution to do so much of activity. Next one. So we need to really, therefore, appreciate the fact that central to the entire thing is the process of conducting IP search. So, how many of us are trained in doing intellectual property search? Is training for search for intellectual property a part of our curriculum? We are learning about the subject of intellectual property rights. Good. But are we conducting IP search? Question to ask. Because if we do not conduct IP search, I do not know what is already there. I may be ending up doing the same thing. Therefore, searching for IP is also important. That is, searching for existing IP so that you don't end up making the same. Now, therefore, we also need to look at actually how to look at the cost for IP, how to process the filing for IP. All of this we need separate training. When the R&D requires training on IP search, but the administrative units have to look at how to really hasten the filing of IP. Do we have a 72-hour timeline? Within 72 hours, IP should have been filed. If I'm taking, let us say, 2 weeks or 3 weeks only to file IP, then the 3 weeks is actually a depreciation cost when it comes to IP. We cannot afford that. So therefore, that we need to really look at a little strategically. R&D organizations, we don't look at it strategically, but today we are not in a comfortable time. We have to look at things very strategically. So that outcome is very important. For instance, I give you in the next slide, the patent protection process. Suppose, let's say we come up with an invention. Next slide, please. Yes, we come up with an invention. Look at the process. You have to run a search, you have to fill an application, you have to search for whether it is, prepare the invention disclosure, convert that into a filing, and ensure that you have met the procedural formalities. Patent office will examine whether approve or it may not approve. So with such a robust process which requires timelines, which requires submission, we need to go very informed into the process of securing intellectual property rights. And that's exactly what I want to emphasize on. So we need to look at strategy for filing. The next slide talks about that. Next slide, please. Yeah. So patenting is a strategy. You must know how to strategically use your property. You don't buy a property to keep it vacant. It will be called vacant land. If you buy agricultural land, you should either be able to sell your land, tenancy, or you should grow the cultivation in your own land. Then you are making better use of the land. Agricultural land is a property. Same thing with intellectual property. If you secure intellectual property but you are not able to strategically use it, then that property is lying vacant. And this is where we need to understand whether the filing is it for domestic purpose. I want to come to the domestic market. I also want to explore international markets, in which case you will also initiate international filing of that particular application. So understanding market considerations is very important. And sometimes we often also do what is called feasible market survey, so that we understand that okay, substitute technologies are available or existing patents are available. That helps in coming up with a strategy. So the next one is about, next slide tells you about IP commercialization. Why we need to understand the facet of commercialization, because once you have property right, I can sell the property, I can sell the patent. It's a property like agricultural land, I'm selling it, I can sell patent also. I can license it, I can assign it. I can go to the bank, State Bank of India, and ask for investment. I can go to investor and say, this is a valuable property, give me funding. JVs can actually help. I can have spin-offs. So all that I can do if I have IP. So therefore, recognizing the value of IP is very important. Okay, so next slide, please. Last set of 2 to 3 slides only. Yes. So as an institution, we need to appreciate the phase of IP, pre-IP, adequately important, because before IP, if you go and reveal that at a conference, have a nice chat with a great person, remember you are disclosing IP, someone may be harvesting it. So pre-IP is important. Post-IP is also important. IP phase, that is from the document to the IP filing. Both of all these things are important. And finally, we need to be also ready for doing what is called preliminary market survey. How often do we tell our inventors, okay, you have come up with great technology. Who is the buyer? Who can be a potential buyer? Today, I'm happy to tell you, I'm in fact very proud to tell you, some of our inventors, uh, those days we used to tell them, please come up with, some buyers. Today, they actually do even their own patentability search. They tell you exactly where it is novel, difference between the patent and their invention. And they also have very clear goals with respect to who are the possible buyers and how they want to interact with the buyers for selling the technology. So it's a pleasure sometimes to see some of these technologies being transferred to big companies, startups being formed. So we're in a very nice time, and taking this forward is important. Why? Because when there is property, you can monetize the property. Just like you go and put jewelry in the bank and you can earn out of that, right? So similarly, this is another property. And that is where we come to the term called IP monetization. Is nothing but realizing the sale value of your IP is nothing but IP monetization in the most simplest sense. So the more you monetize your IP, the better it is. Today, it is no longer about big companies having portfolios. Big companies are coming to startups to buy technology. So monetizing IP assets can be very, very relevant. Imagine a cinema production. Okay, if they did not take copyright, if they don't have performer rights, do you think they can become blockbuster? Next day, it will be pirated. So they secure rights on it. Similarly, IP rights, therefore, whatsoever they technical or non-technical, it is important to first secure the right and realize the value of it. Yeah. So that is almost the last slide. And thank you so much. The last slide is this, my law school's picture. These are the two courses that we offer on the NPTEL. One of them is a very unique course, possibly the only course offered in the world, patent search and analysis on a public platform. We also offer another course called biodiversity protection, which is there in the NPTEL. Thank you so much. I know I spoke for a long while. I'll be happy to take some questions. Thank you so much. Any questions?
Good evening, ma'am. I am Dr. Sahai Chitra from St. Xavier's College, Palayamkottai.
Okay,
Ma'am, I have one doubt.
please.
Ma'am, I published one patent regarding NLP area. Can can I get a grant for this? Kindly differentiate the grant and the patent published. I don't know the difference between the patent published. I published the patent, but now my institute
Okay.
insists me to get the grant for the patent. So,
Okay.
what's the reason why?
Okay. Yeah, Madam Chitra, Madam. So you have a published paper and you also have filed a patent application, right? That's correct. Is that correct? First, my understanding.
Yes, ma'am. Yes, ma'am. Yes, ma'am. Yes,
Yes.
ma'am.
And that patent is not yet granted, right?
Yes, ma'am.
Okay. Okay. Now, what is the difference? See, your publication secures you copyright. Your journal
Okay.
publication has a copyright. Okay. Copyright
Okay.
is a separate one. Okay. Copyright can take care of what the written part of it. Okay.
Okay.
Whereas a patent right will take care of the technology.
Okay.
So if you have to effectively protect your technology, you cannot protect it by copyright because copyright is only on the written material. Suppose, let us say I read your paper, I can get inspired by it, I can modify the product that you made, and I'll go and file a patent. I'll avoid your publication completely because I've modified it. Right?
Okay. Okay.
I'm not
Okay.
infringing on your copyright in any case. I also will come up with a nice text, but the text is not same as yours. The product is not same as yours. Mine is a modified product. I will go
Okay.
for a patent right. Why? You are the prior art for me. Before my invention, you published it. So you are the prior art. But I'm meeting novelty because mine is a new product. One change I do to the product, immediately I'm getting novelty covered.
Oh,
So
okay.
why
Okay.
is it important to get a patent right? Now you have got you've filed for the patent application, right? Now
Yes.
I believe that is published. No, that's what you said.
Yes, ma'am. Yes, ma'am. I published the
Okay.
patent. Yes.
So that is a publication. Okay, good.
Okay.
It's good you asked this question. So you have a journal publication. You also have a patent publication. What is the difference? A patent publication will give you a provisional right, a provisional property right. So let us say, okay, I read your paper. Good, no problem. I'm modifying it, whatever. Done. Now
I,
let us say your patent is published, right?
yes,
Now
ma'am.
the
Patent
moment there is a
published.
publication of a patent, it is a publication of the provisional property on that patent on the
Okay.
website
Okay.
of,
Okay.
and you are having it. Now let us
Okay.
say your institute is saying get it granted. No, it's
Yes,
good.
ma'am. Yes,
Why they
ma'am.
are saying that? If you file for an examination request, it will go into the examination line. Okay, it will be
Oh.
examined, and let us say you get a grant. What is the grant? The grant is a validation of your provisional property.
Oh.
It is a validation. See, when you go for a flat booking, what do? You go and book a flat, right? Your house is not there still. You've
Okay.
just gone and booked a flat in some region, So you also went, someone else also went. They said, okay, this is where the corner of this building is where your house is going to be. That is your provisional property.
Yes.
Okay. That's your
Okay.
provisional property. Now let us say I found out that you have booked a flat and I am now going and living there every day.
Oh.
Okay. Now what has
Okay.
happened? You don't yet have a registered property. When your house is made, you will get a registered property document. Property
Yes. Yes.
document you will get. Now
Yes.
what
Yes.
you will do, you will take me back to that date when I was just like that going and sitting there in that place when your house was not there. Okay.
Okay.
Then till back that date you will claim damages. You will say that I had a provisional property at that time. I did not have a valid property. But
Oh.
nevertheless you were infringing on my property. Why? Today I have a registered property. Because I have a registered property, I am taking you back to the provisional property date and telling you you were infringing on my patent since that time. Pay the damages. So I will get damages from that person from that date, not only from the date of the registration of the property. You're getting it right? That is the
Okay.
advantage.
Yes.
That we
Sure, ma'am.
say a publication of a patent will give you provisional rights on your invention. A journal publication will not give you provisional rights on your invention, please,
Okay. Okay.
because that
Okay.
is
Okay.
copyright.
Okay.
Because that is copyright. But
Okay,
if you
ma'am.
publish the patent application, you're getting provisional rights on the patent. Now, let us say I
Okay.
infringe on you. I am actually not infringing. I'm using your technology. You will wait and watch. The day you get a grant, no, you'll bring me back to today's date and say, pay the damages for all this timeline since the time when you were actually trespassing on my property.
Okay, okay,
You get
okay.
it, right? So this is
So
the advantage of a patent right. It's property right.
grant, copyright, both are same.
Sorry?
A grant and copyright, both are same.
No. Patent grant is different, copyright is different. See, copyright is valid for a particular duration.
Okay.
Okay. Patent
Okay.
right is valid from date of filing to 20 years. And the patent right, you're getting it on the technology, the application of the technology. Copyright,
Yes.
you're getting it only on the writing of that.
Okay. Okay, ma'am. Okay.
Now, let us say you don't want to patent it. Suppose,
Okay,
let us
ma'am.
say you don't want to go for patents. At least go and file defensively, file for copyright. But then you can go for a journal publication, but you will have to watch out. People can easily modify your technology. That's why
Yes.
we insist on, if you have a publication, within 1 year, please file a patent. That is the grace
Okay.
period. Indian Patent Office
Okay.
gives what is called 1 year grace period. You can still
Okay.
not lose the
I published,
invention.
ma'am, but didn't get the grant only.
So you to file for request for examination. Once there is a grant, no, then if anyone is infringing, you can claim damages from them. You can earn from that trespass of the property.
Okay, ma'am. Sure.
You can
Understand, ma'am.
also license your invention better. Sometimes industry believes in inventions if there are grants. You can yourself make the technology and then you can prevent others from manufacturing it.
Sure,
Suppose,
ma'am.
let's say I put up a big manufacturing unit. Okay, let's say you put up a big manufacturing. No one can copy it. Why? You have a property right. That's why.
Sure, ma'am. Okay, ma'am. Okay.
It is like,
Thank you.
can anyone enter your house easily? No, they cannot. It's your property.
Yes.
Same thing here. No difference.
Okay, ma'am. Okay. Thank you, ma'am. Thank you, ma'am.
Thank you, ma'am, for the excellent and
Madam,
informative session. So,
I have one
due to
question.
time constraint, we are moving on to the next speaker,
Yeah.
Dr.
Sure.
K.T.
Please.
Varghese.
Thank you so much. Yeah, thank you so much. Yeah.
Thank you,
Madam,
ma'am.
I have one question. It's a small question. Hello.
I think you can send it to Rashmi Madam. Sir is already here. I don't want to cut into his time. I think it's not right. So you can please send
Ma'am,
a.
ma'am, can we get your particularly mail ID or something else where we can put
Yes, sir,
down
you please
some
take it from
queries of
Dr. Rashmi
ours?
or Dr. Shakti Vela,
Yeah,
and
we'll
you can
share
write
it.
to me.
We'll share it in
put
the
it down in
comments.
the chat box.
Yes.
Yeah.
Nice to
Yes,
see
yes.
Dr. Varghese, sir. Very nice to meet you.
Yes.
And thank you. Thank you so much. Yeah.
Thank you, ma'am.
Thank you.
So now we move on to the second speaker of the day, Dr. K.T. Varghese. I'm delighted to introduce Dr. K.T. Varghese, an eminent polymer scientist, intellectual property counsel, and patent agent exam trainer with a distinguished career spanning over 3 decades at the Central Power Research Institute, Bangalore, where he retired as additional director and group head. He has made significant contributions to material science and engineering. Dr. Varghese has authored 78 international publications with over 5,500 citations and an H index of 35, and is recognized PhD guide and examiner. He has also successfully mentored 28 patent agents in recent years and is the founder and director of Conclavit, an initiative dedicated to education and innovation in intellectual property. We are privileged to have such a highly accomplished scientist, mentor, and innovator with us today. So, please. So your mic is on mute, I think. We cannot hear you. So kindly unmute your mic.
Okay, am I audible?
Yes, sir. Yes, sir. Now it's audible.
Thank you, madam, for your kind introduction. And I'm very privileged to speak in this occasion. and I extend my great regard to Dr. Shaktivel for inviting me for this occasion, and I'm more honored to speak along with the Professor Padmavati Madam, and happy to see you, Madam, here. Yeah. So the topic Dr. Shaktivel asked me to talk is on strategic patent drafting in healthcare innovations. Is my PPT is
Sir, it's
visible to
visible,
you?
sir.
Visible.
Yes, sir, it's visible, sir.
Okay. Okay.
Your
So,
voice is too low, sir.
okay. Okay. Voice is too low. Okay. Okay. So, as I said, the topic given to me is strategic patent drafting in healthcare innovations. Let me tell you, this patent drafting is not so simple as we think. You know, I run this course on patent drafting from April 1st to December 31st every year, at least 5 to 10 hours per week, in the form of coaching patent agents. Okay. So anyhow, I will give you a small flavor of it, and my teaching method is little unconventional. Okay. And I will take you through some PPTs, as well as I will take you to navigation of certain patent examples also. At the start, I will have a disclaimer, because this lecture is intended solely for the educational training purpose at the PSG College of Arts and Science, Coimbatore. It does not constitute legal advice or guidance on any national or international laws or policies. Let me tell you, we are talking about, our focus is drafting. Patent drafting is not just an English writing. Okay, of course you need some mastery in English, but more than that, you should know the law. Okay, what is drafting is you are applying law in a technology. Okay, you are drafting your invention in the eyes of law. In the eyes of law, if you want to draft, you should know the law. Without understanding, also people are drafting without understanding the law, without knowing the law. There are so many inventors, they draft themselves, and they create, a lot of pitfalls in filing. Then they will come to patent agent when the first examination report comes. It will be very difficult to rectify things there. So please know that patent drafting means understand the law first. Understand the law first. If you don't know the law, it is difficult to draft also. I will tell you how I will substantiate this point today with some few examples. See, my teaching is embedded in National Education Policy 2020. Okay, in our new education policy, we should have all modern methods of teaching. It should be an inquiry-based teaching. It should be an innovation-based teaching. It should be multidisciplinary lessons, and it should produce an impact, okay, on the learning as well as on the teaching. Okay. NEP 20 and innovation ecosystem, to give a few, this is my introduction, common introduction. I had this slide. I didn't know that, time is short. Anyhow, I'll just read it out. So let us note that the new education policy of Government of India demands that there should be an encouragement of innovation and entrepreneurship. It mandates establishment of innovation and incubation centers. It promotes interdisciplinary research. It recommends IP training for faculty and students. The IP training for faculty is very important. Every faculty, okay, when I was also a PhD student, I was also trained by my professors to write a paper, journal paper, but I was never trained to draft a paper, patent. So this is now important. Okay, if you see this, look at this NEP policies, you understand innovation has to go. If innovation has to go, you should have a IP registration. If you have IP registration, your institute demands that you faculties help your students to draft patents. If you want to draft patents, if you want to teach your students to draft patents, you should know how to draft it. Okay. This is happening everywhere. Everybody is publishing. Every teacher is teaching how to write a paper for a nature journal also. But sadly, they are not attempting to learn the drafting and teach the students to the drafting aspect of patent and help them in filing patent. In this respect, to help teachers and faculties, inventors, I started this training program. It's an exhaustive training program. Every year I start from April 1st to December 31st. I conduct my classes in the morning from Thursday to Sunday, 5 hours, 7:15 to 7:30 to 9. Similarly, evening also 7:15 to 7:30 to 9, Thursday to Sunday. 5 to 10 hours I invest. And this, my drafting class is such a long class. Teach them law and then time to time help them drafting. As soon as they progress with the law, refine the drafting. Okay. So this refining is also important. The more you understand the law, the more you are able to draft. Drafting means not only just a complete specification drafting. Drafting also means give an FER reply, give a pre-grant opposition, give a post-grant opposition, give a reply to pre-grant opposition, give a reply to post-grant opposition, things like that. Okay. Turning to next slide. Next slide. I want to ask you, I told you my method of teaching is almost NEP style of or to fulfill the NEP objective of the nation. So I always prefer inquiry-based learning. I always like inquiry-based teaching. Okay. To give a flavor of that, can you tell me, do you understand what is an innovation? Do you understand what is an innovation versus invention? What is the difference between discovery and inventions? Can any of you please tell me so that I can start from there or I can skip this topic? Okay. Innovation, invention, discovery, triads. Can anybody explain here? Any teacher, any student, anybody? Will you please volunteer yourself? Anybody would like? What is innovation? What is the difference between innovation and invention? What is the difference between invention and discovery? What is the difference between innovation and discovery? The triads. Can anybody tell? 10
Sir,
seconds.
this is Krishna Veni, Assistant
Krishna
Professor,
Veni.
Microbiology, PSG College of Arts and Science.
Yes.
Innovation is any small modification in the existing product which brings a commercial value to the product.
Okay. Then invention, discovery. What is the difference
Discovery
between
is
innovation
historic.
and invention? Difference between innovation
Yes,
and
sir.
invention?
Yeah, discovery is a historic, once in a time done. For example, the first time when antibiotic was discovered by Alexander Fleming, it is a discovery.
Good.
So when the second time and third time something is done, then it's invention. And when there is a commercial value to the invention, it becomes an innovation.
And invention?
Invention is when it is put into application.
Everything is partially correct, not fully correct.
Okay.
Can anybody have any other answer?
Yes,
sir. The answer.
Myself, Ishita.
Partially, yes.
Sir, this is Dr. Rao from Lovely Professional University.
Yeah.
Innovation is
Dr.
very
Rao, I congratulate Lovely Professional University. You are You are filing so many patents, you are topper. Okay, in patent system. I congratulate you. I always admire Ravli Professional University. I always give you an example. Okay, the university example as a case study in my lecture. Please proceed.
Okay.
Yeah.
So invention is completely first for the first time creatively a new idea has been developed. Invention is the modification for the innovation or a practical or refinement of innovation. Will be
Okay,
called
sir.
as
It is not
invention.
fully correct, but it is partially correct. Okay, proceed.
Hello. Hello.
Yes,
May I speak?
please speak.
Myself is Dr. Ishita from Netaji Subhas University, Jamshedpur.
Yes.
Discovery means finding
No,
something.
come to innovation and invention difference. Discovery almost everybody is clear. What is the difference between innovation and invention?
Invention is creating something new.
Excuse me, sir. Hello.
Invention is creating
See,
something new.
this is a
Hello.
topic. This is a topic. It is not properly taught by teachers. It is not properly learned by our students. That
Good
is why
evening,
I
sir.
take this topic. It is even there are IIM faculties who are teaching. I have heard they don't define it properly. Let me tell you. So this is something very valuable for us to understand. Let us understand. Yes. Anybody else?
Good evening, sir. So am I audible?
Yes.
This is Dr. Prabhakaran.
Yes.
Department of Botany, PG College of Arts and Science.
Yeah.
Sir, invention, 5,000 years back, the wheel have been invented. But last 60 years before, the wheel have been inserted in the suitcase. That's what we are trially was. So invention was made in the 5,000 years before, but innovation, the wheel have been.
Sir, these are all answer from logic. There is a text material for this.
Yes, sir.
It is your own logic you are telling. It is not that. Either it should be taught by a teacher or it should be learned from a text. Can anybody else try to give a better answer? Anybody else? Any lawyers? Any IP strategists? Any IP attorneys? Any IP faculties? Welcome your answer. Anybody else? 10 seconds. Okay. I will tell you. Innovation. Innovation means any technical advancement, creative technical advancement in any walk of life. Innovation means any creative technical advancement in any field of technology. Innovation means any creative technical advancement in any faculty of knowledge. Discovery means it was existing. You went and found, right? Like Krishnavani told, once it happens. Once it happens. Correct. You discover things. You discover a property. You discover a use. Something which is existing. You discover a natural material which is already existing. Okay. Then what is invention? Okay. Have you understood what is innovation? You have to understand thoroughly what is innovation to understand invention. Okay, let the discovery be there. It is easy. We discovered something which was not seen but which was existing. Discovery is made by God. Let me tell you, whatever God made and kept, we went and found. So innovation, I told you 3 things: creative technical advancement in any walk of life, in any faculty of knowledge, in any field of technology. Then what is invention? Invention is not something you get from a dictionary. If you get from a dictionary, if it gives the right meaning, it is okay. But it is unlikely to give you a right meaning. If you search in Google also properly, it is unlikely to give you the exact meaning. Okay. Invention is defined according to the law of a nation. Understand? It is according to the act which become a law, which is signed by the President of India or the President of the country. Okay. There the definition. So invention is not something you can say logically the meaning. Invention is not something which you can just imagine or something easily found, because invention definition vary from country to country. Understand? Invention means a new product or process involving an inventive step and capable of industrial application. This is the law and definition of invention in India. Understand? Appreciate? Any comments? So this is the relationship. Innovation means any advancement in any walk of life. You may dress in an innovative way, walk in an innovative way, and you will make a makeover in an innovative way, teaching anything, any field of technology, any faculty of knowledge. But the innovation can become invention provided satisfy the law of the nation. What is the law of the nation? Can anybody say? I told. Can anybody repeat me? Once I recited. Anybody? 10 seconds. Once more. Invention means a new product or process involving an inventive step and capable of industrial application. This is the definition of invention. Innovation is also invention. Okay, innovation is not invention. All inventions are innovations. All innovations are not inventions. Do you understand? All inventions coming out of innovations. That is why we always talk about innovations. We teach innovations. Okay, but for invention to come is a different thing. Anything is innovation, any technical advance. So please understand that all inventions are innovations, but all innovations are not inventions. Okay. Any kind of modification, yes, please. If you have any dispute, if you have any comment, if you have any argument, if you have any challenge, if you want to impeach my statement, please welcome. Or if you want me to explain it once more, also I can. Okay. So that is what it says. Please understand that invention is defined by the law of the nation. According to India, invention means a new product or process. There are only two things in India, a new product or process. Okay, involving an inventive step. Inventive step is also a new vocabulary, which I don't have much time to explain. Okay, the time is short. And involving an inventive step and capable of industrial application. In short, we say novelty, inventive step.
Sir, can you quote an example?
Oh, I will give you hundreds of examples. Please stay with me. How long you will stay with me? I'm going to take you to the example only. Okay, I have the example here. Okay, so saying that, what is the strategic laws? Strategic drafting. I am asked to give a drafting, strategic drafting. So strategic drafting, there are laws. These laws are coming from Indian patent system, patent law, patent act. Strategic laws for healthcare is, what is the topic? Let me see once more. Topic is healthcare, strategic patent drafting in healthcare innovation. So the topic itself is not, we can refine it. Okay, it is not correct. I was given this topic, it is okay. Invention is there in innovation. So it should have been strategic drafting in healthcare inventions, because innovations we don't draft for patent. Okay, innovations cannot be drafted for patent, only inventions will be drafted for patent. So I will give you example. Okay, so for strategic patent drafting, you should have a strategic law. What are the strategic law which I am going to tell you today? I will show you. Most importantly, in healthcare, the law is section 3I. Then supporting other laws are section 3B, section 3D, section 3E, and section 3P. And then there are many other laws. Okay, I teach these in my class students as pillar laws, the pillars of patent law. Okay, there are certain pillar laws. So these are the few pillar laws which I teach. So Now we have to understand what is section 3I, what is section 3B, what is section 3D, what is section 3E and 3P. If you want healthcare drafting of inventions, first you have to understand minimum this law. Okay. So do you have enough time to learn now itself? Okay. Just you understand the parts. Okay. So let us go to the law. What the law say? 3I, any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic or other treatment of human beings or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. You should be able to read it properly and then you should be able to understand it properly. Let me tell you, it is not so easy. Okay, even reading itself is not so easy. So what people do, they will dilute, they take the points and teach. But let me tell you, as a teacher, I teach my students directly from the legislation. I don't convert into PPTs. So please, the gist of this is that any process means what is the process? Invention means a new product or process, that process. Any process for the medicinal surgical is not patentable. This is not patentable. So understand, when you make an invention, when you draft an invention, it should not give it should not give you have made a big invention, big innovation, but you should not claim in such a way that you are drafting a process of medicinal surgical treatment. Very foolish thing. If you don't understand the law, there are many faculties, they don't want to consult patent agents. They are well learned, they are doctorates, they are well accomplished. I'm not blaming, but they don't want to use the service of patent agent. They themselves do it. Finally, it will be published. Then I have so many examples. Okay, it will be published, but further they cannot proceed, they cannot answer. Even if an FER report comes, it is not drafted well, you cannot add a new matter. We cannot, we cannot restore it, revive it. It is very difficult. So before understanding the drafting, this is a must. Now, if you want to understand today, if you want me to show healthcare drafting, and without teaching this, it is difficult for me. I don't do this. I will not be doing a justice to my teaching. Okay, if I at least don't give the importance of this. Okay, then the next law. Okay, this law, please try to understand. It is very difficult to read it and understand it if somebody is a first timer, whoever it is. Okay, it has to be explained. It has to be tutored also to understand this. I'm not going to it, but this is just to understand this method. Treatment method is not patentable. Therapeutic method is not patentable. Even to treatment of animal is not patentable. Even to increase the economic value of the animal is not patentable. Even to increase the economic value of the method, the process to increase the economic value of the animal product also is not patentable. So there are so many limbs here. Multiple limbs are there. To understand this, it takes quite a lot of time and detailed class is required. Okay, that's why I have an extended class. Okay, let us come to the next one. The key law is 3I, section 3I. Then again, you come back to our invention. Invention means a new product or process. Here it says process is not patentable, but product is patentable. Let me tell you, if you have a product, that is why pharmaceutical drug is patentable. Okay, in medical field, healthcare, but healthcare process is not patentable. So there also you should understand. So when you are having an invention, if it is a process, leave the process aside, take the pitta and marrow, or make a pitta and marrow analysis and take the product out and make a claim for the product. Let the process be there, let it be described in the specification. Okay. Now, next one, what is 3B? An invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal or plant life or health or to the environment. This is also like that. Very difficult to read in first. Okay. And for a lawyer, it is difficult. It is a different thing for a lawyer. But I'm telling you, for an ordinary person, for a non-lawyer, very difficult to read, very difficult to decipher it first time. Okay, but this is required to understand. If you want to do healthcare drafting, you have to understand. Hair splittingly, you have to understand this law. Okay, in short, a small limb I will tell you. Anything which causes serious prejudice to the plants and animal, even environment, okay, or health are not patentable. So any invention, whether it is a product, whether it is a process, if it causes serious prejudice to human health. So what is prejudice means? In simple English, you can say a harm. It should not be harmful. You can see in this category, you can get several examples and fight and legal battle from Indian Tobacco Company. Okay, they have so many cigarette patents. They have patents. Somebody asked me to show me the example, but before showing the example, at least I have to say, I can show you the example after finishing at least few slides. Okay, so for instance, Indian Tobacco Company, so many patents they have, but they are cigarette-based patents always. They have electronic cigarette-based patent. They always will have this objection, 3B objection. They face 3B objection, they battle it, they get it, sometimes they get, some patents are refused. So understand which are the section. Governing sections are 3I, 3B in healthcare. Next one. Next one, 3D, very complicated, only for India, this one. A strict law, okay, established by India against patenting, incremental patenting. And this 3D also has to be fulfilled for healthcare. It is particularly in pharmaceutical. The law is made purposely for pharmaceutical, though it is not mentioned that way. Because based on the Novartis case, it is fixed of the law meant for pharmaceuticals. What is it? The mere discovery of a new form of a non-substance which does not result in the enhancement of the non-efficacy of the substance, or the mere discovery of any new property or new use for a non-substance, or of the mere use of a non-process machine or apparatus, unless such non-process result in a new product or employs at least one new reactant. This is the legislation. I have not tinkered with the legislation. I have not diluted, or I have not taken bullet points. This also has to be understood. What does this indicate? There are so many limbs here. You can see, you can take it as a substance for one part, process another part. As far as substance is concerned, it should not be a mere discovery of a new form of a substance, new use of a substance, new property of a substance. These three things. Okay. It should not be a non-substance, mere discovery of a new form of a non-substance. A substance is already known. It should not be a little more discovery of a new form. Novartis case is the landmark case, alpha form to beta form they made. Novartis, okay? Alpha form of this imatinib mesylate, okay? It was alpha form, it was available, they made, and then after the time is to over, they wanted to patent it in the beta crystalline form. Okay, beta crystalline form is always evident from the prospect of beta crystalline is was evident from their first drafting itself. Anyhow, they battled it, they got patent from other countries. They didn't get patent from in India. It is a 2013 case, very landmark case. Okay, it created a lot of trade relations with India and other countries. So what was that there? Mere discovery of a new form of a non-substance. Imatinib mesylate is known as an alpha crystalline, and then they made a beta crystalline. What is the beta crystalline? Beta crystalline has a better shape. Beta crystalline will flow. You put it in the funnel, it will flow like this. Alpha crystalline will not flow because alpha crystalline will be hygroscopic, so it will absorb moisture. So you have to fan it like this. You have to shake it to flow, so that better flowability. But there is no therapeutic efficacy. There is no enhanced efficacy. So there are certain. So this is the thing. So another new property or a new use. As far as a process is concerned, the mere use of a non-process is not patentable unless there is an employment of a reactant or it results in a new product. Okay, this is the interpretation. Even this has to be told limbo-wise, several times. Some people will understand in a first explanation. Some people will require more explanation. Okay, so we understand the governing laws are 3I, 3B, 3D. Now coming to 3E. 3 is very interesting, very easy to understand. What is it? A substance obtained by a mere admixture resulting only in the aggregation of the properties of the component thereof or a process for producing such substance is not patentable. These are all coming under, there are 15 laws. Okay, they are called what are not inventions or non-patentable subject matter. So 3E. Okay, so now I will take you, okay, where you get this. Can you see the screen? Can you see the screen? Dr. Shaktivel, can you respond? Can you see the screen?
Yes, sir.
Yes, sir.
Yes, sir.
I like some interaction.
Yes, sir. It's visible, sir.
All of you are familiar with this, or if you don't know, you should know how to navigate and what are these things. Come here. I told you before understanding the before drafting, you should understand the law. Where you get the law? You can buy a book, or everything is available here. Go to Acts and Rule, Patent Acts. Open here. Whatever I teach you is there. I take this directly from my class. Section 2. Inventions. Where is invention? Section 2(1)(j). Where is it? 2(1)(j). Can you see? It is a small letter. Invention means a new product or process involving an inventive step and capable of industrial application. So I told you 3I. Where is it? 3I is here. Any process for the medicinal surgical, okay? Same, without changing the legislation, I copied to the patent. Then I told you 3B, okay? 3B, an invention, the primary or intended use or commercial exploitation of which could be contrary to public order or morality, or which cause serious prejudice to human, animal, or plant life or health or to the environment. Then which one I told you? D, the mere discovery of a new form. Then E, okay? What is E? A substance obtained by a mere mixture resulting only in the aggregation of the properties of the components thereof or a process for producing. This means that by mixing, a mere mixing, okay, two solid you are mixing together, it does not resulting in the, it will result only, it is a mere admixture resulting only in the aggregation of the properties or a process to produce such mixture. Both are not patentable. Okay, both are not patentable. Something which you can mix and then it will have a, it can be separated also, it will be independent of, its function will be independent of one another, and it will not produce any effect, and it will not produce any effect. It will just give an additive effect. If you draw a property versus the composition, okay, you are taking two mixers, 0 to 100, 0, 20 and 80, 30 and 70, 40 and 60, like that. You will get a straight line. How? A sliding straight line, because just additive properties. You take the average, that physical property, refractive index versus this one, composition. Whereas the diffractive index versus composition, if it is away from some composition, there will be a peak. Some composition, there will be a depression, either a convex curve or a concave curve. There lies. That is not a mere admixture. That will have an effect. Okay, there is a reactive component, and those type of properties are called synergistic effect. Okay, when there is a, if it's a mixture, If it's a synergistic effect, it is patentable. Otherwise, if it's a mere admixture, if it is giving only additive property, it is not patentable. That is 3. Then there is one more law which is governing for healthcare is 3P. An invention which in effect is traditional knowledge, or which is aggregation or duplication of known properties of traditionally known component or components. It is very important how to read this law. Many people teach, many faculties I am teaching. Invention related to traditional knowledge is not patent. It is not like that. Please don't say that. Please don't say that. If you are a IP practitioner or IP related field, or if you want to convey IP, or if you want to teach your students IP, you should not say invention related to traditional knowledge is not patentable. Please see, an invention which in effect, everywhere there is a phrase here that emphasizing impacting phrase is there. Even the previous law phrase was there. I didn't give importance to that. Whereas here I give importance because there are so many traditional knowledge based inventions are there. So many mechanical inventions are there. Material herbal inventions are there. Biotechnology related inventions are there. Chemical inventions are there. Mechanical inventions are there. Chemical biotechnology, agriculture related inventions are there. Okay, traditional knowledge. So when you read this law, very important to understand that an invention which in effect, in effect. Okay, so when you teach somebody, you should say an invention which in effect is a traditional knowledge is not patentable. Or you can say an invention which in effect is traditional knowledge, or which is an aggregation or duplication. Some notice is coming. I don't understand. You can ask me. Okay, you can ask me what you want to convey. So an invention which in effect is traditional knowledge, or which is an aggregation or duplication of non-properties of traditionally non-component or components are not patentable. Okay, so whatever the traditional knowledge which is used as such by the local community, if you read when it is not patentable. But if you make a value-added product from that, value-added technology from that, you make you do some intervention and make a process, then it is patentable. Now, with this law, this is the basic law for drafting. Now I come to a real example. Okay, I will give you a very latest example. Okay, where I will go. I will go here only. I will give a very latest example. Okay, please see how I do. Many people may not know how to navigate this. Go to dynamic utilities. Go to dynamic utilities. You will get a very latest approach of drafting. Okay, in my class also I do this practice only. I take the latest examples, multiples of examples, hundreds of examples I take. See, open here, disposal of patent applications. Okay, you will be taken to another screen. Can you see this? Biotechnology, chemical, electrical, mechanical. Okay, all fields of technology are classified into 4, and every month whatever patents are granted, the full details are accessible to anybody from the patent office. Okay, the full details. Okay, let us go to Mumbai. Okay, 6 patents are granted. Today is 15, from 1st September to 15. Let us go to Mumbai. Let us take one patent. Something related to anybody has any special title? Anybody is interested in any special title? Or let us take this. Okay, let us take this. You want to know drafting, and my method of teaching. I am teaching my method of teaching. How I do. I don't go by some hypothetical examples and draft. I don't do that. I always take a well-finished. Always I take as many solved examples as possible. Okay. Always I take the solved examples. This is my method of teaching drafting. Okay, it takes a little time to open it. If we have to open, then only I can explain it. It's a granted patent. Okay, it's a granted patent. cannot see my screen. So many things are standing on the stool bar. My method of teaching is that I use WhatsApp also. I brew my lessons like this. Immediately I transmit to my class group. This is my class group. I transmit like this. So that is what I usually do. So that is the way now I am practicing. And this has to open. You have to put up with me till the example opens. So we are taking a Mumbai example, recently granted, and I am trying to give you a flavor of teaching. Before that, what did I do here? I taught you the law, or I told you the importance of the prerequisites before drafting in healthcare. Okay, and before that, one has to understand what is innovation and what is invention. Okay, that is a must. Okay, the law, first law, you have to by heart. All of you have to by heart. If you want to do something, you have to by heart. Invention means a new product or process involving an inventive step and capable of industrial application. By heart today, here itself. Okay, it is a must. Then only you can draft. So this is taking some time. This is taking some time. Okay, this is taking some time. Then okay, then these are other laws. Okay, then okay, as it come, okay, it has come. You see this? This is from our Indian fraternity only. Advanced Center for Treatment, Research and Education in Cancer. See, their patents is available here. We can take for study for our educational purpose. It is filed in September 2024, 1 year ago. Today is 15. 27/9/2024 it is filed, and they got the patent granted 4 days ago, 11th September 2025. And what we will do, we will view the documents. Okay, let us view the document, and I will show you where I am going to teach you for the draft. Multiple documents are there. From there, I will select a few documents and then explain how they drafted it. Okay, rather than how I draft, I will tell you how others drafted, which I will teach. Okay, so that way I am not creating, I am only imparting the knowledge. That is what a teacher does. The best lessons a teacher takes and impart the knowledge. Okay, they create also knowledge, they publish, they take PhD by creation, but that is not the thing we are doing now. I am only imparting from the best practice, best drafted, and I am explaining how they are drafted. That's what I'm doing. It takes a little time because of the internet. Meanwhile, we can go to the law. Okay, so these are certain laws you have to understand. Let me tell you before drafting. It is not, it is, and meanwhile, you can ask me any question while it tends to open. Any question on patent you can ask, any difficult question also, and I will take it as a challenge. Let me try, let me test my capability also, and so that it will help me to learn also. You can ask me any question on patent, Indian patents. Meanwhile.
Sir, hello.
Yes.
So this is Dr. Avinash Pansai from Bharati Vidyapit Deemed University. I just
Yeah.
wanted to ask one question, which is related that if we have got some design patent, can we go for that particularly design patent into the patent utility again? That is, if we have some prototype of that particular design, and can we go for it
Very
again?
good question. Very good question. It is a matter of strategy. Very good question. See, you should understand what is a design first. And you please don't say design patent in India. This is the problem with all teachers, university teachers. I have a design patent and I want to do a design patent. And what is this design? There is nothing like design patent in India. Okay, it's only a design registration, design rights, design protection. Patent is only for invention. Patent is not for designs. Please understand. Okay.
So
And
for design, we don't have to call it as patent.
Never call, never teach also like that. Please. I have heard teachers also do the same thing. That is why this faculty FDP program is very must. Very, very necessary, even for IIT faculty also. Even for IM faculties also. Very, very essential. Say design patent to anybody. Patent is only for inventions. Okay, now design registration. Now your question, whether design should be applied first or patent should be applied. Never apply design first. First you apply for patent. Patent. The examination is tough for patent. Examination is tougher for patent than copyright or design. Okay, so if you have an invention, you may be able to patent, you may be able to design. So after filing your invention for patent, I don't say utility patent at all. These are all other jurisdiction technology. I will use the term patent. Okay, I am for the nation. Whatever the nation made, I will say patent. Okay, for me, I will never use such a term. This may be from other jurisdiction. So you apply for patent first, then go for design. Okay. Now again you reframe your question if I didn't give you the right answer. Yeah.
Sir. My question next is if somebody files an same design which I have, but he files for the patent, then whose right stands to be the first?
That is
the
also
person who has filed the patent
that
or
is
the person
also
who has
very, very
filed
good
the
question.
design?
See, it is possible that your design may be worked by somebody else. That is very common. Okay, to understand that, one should know the design law 6, section 6. Very, very important. Whereas patent, in design it can happen, duplication can happen. Then what to do? Okay, because design, there are different classes are there. Design can be, you apply design on one article, another person also will apply your design on another article which you have not registered. 32 classes are there. All classes, if you want protection of your design, maximum protection, you should register your design in maximum class. Otherwise, somebody else will put your design on another article. Article is different. You fixed your article design on bottle. That bottle, he may put that design on a bag, and with the bag he will ask for registration. It will happen. So what to do? So in order to avoid that, you should decide. You should know where all you can apply your registration. All 32 classes are there. This is why you need an attorney. Okay, design attorney. You apply your design in all articles, maximum articles, and register. Okay, there are other aspects also to tell, because let us not focus on that. If you are happy with my answer, there are other things.
Yes,
also.
sir. Yes, sir. Thank you. Thank you. Thank you so much. Thank you.
Understand? Yeah.
Yes,
okay.
Sir. Thank you so much.
Okay. Any more question? Welcome. So this is, see, this is their patent certificate. Everything you are getting here. All things. Not able to see my screen. So I will close this. Okay. This is fielding. I'm not familiar with this system. I am familiar with the Google Meet. This is covering my toolbar. Okay, so I told you these are the laws, and these are section 2 laws. I don't know how to move this. My toolbar is, I should learn this technique. Okay, so you can see all this. Can you see? Patent certificate is there, intimation is there. When they started with the provisional or complete. All details are there. So if you want to draft, what you should do, if you want to draft only claim, you can take here. But you can see in this drafting, they would have drafted something, applied something, then finally gradually they refined. And finally they submitted after hearing. Okay, what is the course? The course is like this. You apply as complete specification, then there will be an examination, then the report will come. This is examination report. Then you give a reply. Reply is not satisfied. Again, you modify your drafting. You understand? So drafting is a three-step process. Actually, in normal case, drafting is a three-step process. First is complete specification. It does not end there. You may do some drafting like a journal paper. Still, patent office will accept it. It will publish also. Okay, but that is not a draft according to the law. May not be if you don't know, if you have not understood the law. Then it will be examined. It will be, the result will come as a FER, first examination report. There you will reply. There also, in case it is not drafted, originally drafted according to the law, then it is difficult. To some extent only you can rectify. You cannot rectify to the absolute extent. It happens like that. Because starting itself, you should have started drafting accordingly. After FER reply will come, you will submit FER reply. Even FER reply is also not satisfied. That is why this hearing notice is coming. Okay, this hearing notice. So, okay, that site is not coming. I don't know. So let me tell you, hearing notice will come. Let me see it, whether it will open. Okay, hearing notice. So please understand, drafting is a three-step process. Dear faculties, if you are trying to venture into drafting your own invention, it is your child baby. Please do it very carefully, very knowledgeably, very beautifully do it. Understand the law. Otherwise, you engage a patent attorney. See, it is always this kind of familiar class will familiar you to coordinate or do something like that only. If you want to immerse in the drafting, definitely you need to understand the law well. That is, otherwise, see this process. If it's a good draft, can you see even here complete is there, FER has come, then hearing has come. If it is well written, if it is a genuine invention, after submitting the complete specification without objection, patent will be granted. The drafting also has to be good. The invention also should be proper, genuine invention. What kind of invention? That invention. Invention means a new product or process involving inventive step and capable of industrial application. Anybody wants to tell something, please tell. I'm not able to understand from your chat. You are sharing something. Okay, if you want to say something. Okay, let me see whether this is the hearing notice. Okay, this is the hearing notice. See this objection, non-patentability objection. Can you read this? Can you see this? Let us start from here, drafting. So this is the third stage of drafting. Understand? Not the first stage of drafting. When hearing comes, say, when hearing comes, it is a third stage of drafting. First stage is complete specific. Or you may say fourth stage is starting. There is a first stage of drafting if it's a professional specification. Then you will have to complete specification. Then FER reply. Okay? Professional complete FER and then written submission after hearing. So 4 stages are there for drafting. It is not as simple as that. So see this, they have made a complete specification. They have answered to the FER reply. Finally, what it has come? The functional, see, non-patentability under section 3. Okay, let us see what it says, whether which section is objected. Okay, 3C. Okay, we didn't say 3C. 3I, can you see 3I? This is the governing law for healthcare. Okay, so here objection is there. There were, if this 3I objection may be there in FER also, here also. What is it says? Let us read. If anybody interested and volunteer, and if anybody is in the field of biotechnology or life science, healthcare, if you read, I will be happy. I will give you 10 seconds. If you can volunteer, you read, I will make an interpretation or I will start. Would you like to read or should I read? under section 3I of the Act are not patentable. You see, US means under section. Okay, it is not USA. It U-S means under section. And not patentable under section 3I of the Act. Amended claims 1 to 30. See, 1 to 30. How many claims they have? We have to open. Up to 13, they may have proper, maybe only 30 claims or maybe a little more. Okay. Amended claims 1 to 13 for a composition comprising, amended claims 1 to 13 claims for a composition comprising umbilical cord derived mesenchymal stem cells. Okay, if I don't pronounce it, kindly correct me. I'm not biologist, but still I am supposed to teach biology drafting also, and I do that. Okay, umbilical cord derived. 1 second. I should be alerted. When should I stop? I can continue, but the audience are not there. That is not a happy thing. If the audience are there, I'm happy to continue as long as you wish. Okay. So this is the
So
fourth stage.
we can have the session for another 10 more minutes. Sir.
That is what I wanted to know. Okay. Amended claims. Okay, then let us see how this is drafted. Amended claims 1 to 13 claims for composition comprising umbilical cord derived mesenchymal stem cells. However, the body of the claim talks about MSC. MSC is what? Mesenchymal stem cells. Okay, stem cell based research. And CM, what is CM? We will see. When administered intraperitoneally and intravenously against tumor xenograft led to significant reversal of suppression caused in T cell, okay, B cell, and myeloid cell, mitogenetic responses in presence of leukemia cell, supernatant or matant, bar MSCCM when administered intraperitoneally against MDA B23, one breast cancer xenograft, K562 leukemia xenograft, when administered intravenously against HELA cervical cancer xenograft and A549 lung cancer xenograft enhanced. So this graft, all this kind of graft enhance the reduction of relative tumor volume. So finally the tumor volume has come down by administering this graft intraperitoneally. So intraperitoneally application, okay, as a person, if you are in a different field, if you don't know intraperitoneal, as a patent agent like me, we have to understand. I will immediately do the Google search if I don't understand. Okay, we are supposed to teach all subjects, so we do that. So here you understand it is reducing the tumor volume, tumor size is reducing, which comes under a method of treatment. Oh, this is the objection. You understand what was 3I? What was our 3I? Remember, method of treatment. It comes under method of treatment. Hence, amended claims 1 to 13 are not patentable under section 3I of the Act. So, understand, whatever you do the drafting, if the objection is like this, you are not going to get the patent grant. If the objection is sustained, if the invention is a process for treatment, if you have drafted your invention in such a way that it is a treatment, you cannot do anything. You take a refusal order and leave. That's all. Your money is lost. Okay. So what was 3I? See this? 3I, any process. Instead of process, the word was method there, method of treatment. Any process for similar treatment. Let me do this. Any process for treatment, okay, for similar treatment. This is the way sometimes you can easy to understand. This is the way bullet points are taken. It is not patentable. So what to do? what to do. They have given the answer to this. You can see how they drafted it. This is their written submission. So please ask me, I will stop. Okay, you can call me anytime.
Sir,
If
sir.
I am available, I can come and revise this and continue the class. Okay?
Sir.
Yes.
Related to the example which you have given right now. So this particular treatment process cannot be a patentable.
Not
according
patentable.
to section 3A. Yeah,
Not
according to
patentable. But
section
they
3A.
got the grant.
Yeah.
But they got the grant. So they have drafted in a successful way. But they drafted it. That is where we have to understand how they drafted it.
So
you understand?
So can the process go for the copyright?
You can see copyright any material, unpublished or published, if you have made in a material form, definitely if it is new and original, you can copyright.
Okay.
Your life plus 70 years, your protection. If you have reduced your idea into a material paper form, even if it is not published, you can go for copyright. But madam was told, you remember, as soon as it is created, automatically it is protected. Even if you don't register also, you have the protection which madam taught you in the previous class.
Right.
Okay, any more question? Otherwise, it has to turn. You understand that there is 3A objection. The drafting was improved. The drafting was, strategically changed. Drafting pattern, drafting thing changed, or certain invention they would have removed. Something they did. And to understand that drafting, we have to do macaroni. So let me tell you, if you are asking me today, if you would have asked me, I have this passage, can you draft? I would not have done it. Okay? I always like to teach you a perfect example. I told you, I like to impart the knowledge. That is why I took this example, and this is the way multiples of patents you can learn drafting. Okay? Go this, hundreds of patents you can go. My candidates are able to navigate, read. By the time I teach, they would have read about 500 to 1000, at least they would have glanced, they would have reviewed. Some people ask me before my class starts, how many patent example teach you, how many drafting you teach. I say hundreds or thousands also if you want. Okay? So patent agent exam is open now. Teachers can join. September 20th till date is available. You can write this exam. If you have a science or engineering degree, definitely it will elevate your career. Okay, university and all, you will be able to teach your students. If you understand the law, it is a mark that you are competent. If you pass the exam, it's a mark that you are competent to draft and competent to teach also. So this, if you want, any of you want to become a patent attorney or patent agent or a licentiate of this law, okay, now opportunity is there for 2026 exam up to 20th. You can go to patent office website. Okay, if you want any information on how to apply or anything, you can contact me. Dr. Shaktivel has my number also. Okay, this is the drafting. Okay, you can see how 3I they drafted. Okay, 3I how they drafted. Let us see what is the answer they have given. Okay, non-patentability under section. See, amended claims. They amended the claim 1 to 13. Okay, 1 to 13. They made amendments. Okay, so these are the reply. I am not going into details because 10 minutes is over. That is the reason. Okay, so maybe claim amendment maybe here as attachment. Let us see. One claim, then I can. Yes, madam. Okay, Markle today they amended the claim. Okay, so they amended the claim and they gave the draft answer. Okay, so we have to see how they drafted the claim. Go on, I'm sharing.
Thank you, sir, for the
Yeah.
nice and informative session.
Yeah.
If there is any question, we can take up any one question from the participant side. Okay. So I think if there are no questions, thank you so much, sir, for spending your valuable time.
Okay,
And
thank you, madam.
participants, please note the yes, sir. The link for the feedback has been posted on your chat box. So kindly fill the feedback form. And tomorrow the session will start exactly at 6 p.m. Thank you. So thank you.
Thank you, madam.
Thank you, sir.
Thank you, sir. Thank you, madam.
Sir, thank you, sir. Thank you for your very informative session about the patent draft strategies. Hope we
Yeah,
will
yeah,
meet again.
of course.
Thank you, sir.
Yes.
Thank you so much.
Yes, yes, yes.
Yes, sir. So with this, we are
Call
going
me
to end the
anytime.
first
Call me
day.
anytime. Call me anytime.
Yes, sir.
In this fashion, if you
Yes,
like
sir.
if you appreciate this way of teaching, you call me anytime. I'm available.
Yes, sir. Your live way of teaching with a lot of examples are
Yes,
very
yes, with
interesting.
examples only.
Yes.
With examples only and fully sold examples. Fully sold examples.
Yes, sir. Thank you so much, sir. So hope we will meet again. So participants, for day 2, tomorrow we will start the session by 6 p.m. So with this, we'll end the first day session. Thank you so much. Thank you, sir.